May, may I please, your lordship?
Yes.
My lord, I beg to mention item number 46, my lord, is the sole hearing matter listed today, my lord.
Yes.
My lord, may I pray for a, my lord, short accommodation for the next week, my lord? I
Why?
am, my lord, prepared, moving this petition as a petitioner in person, my lord.
Petition in person?
My lord,
What is it?
file by myself, my lord.
Huh?
File by myself, my lord.
Lordship, in this matter, I
You
am,
paid the challan?
yes.
Yes, I have made it.
Lordship, may dispose of tomorrow or day after tomorrow, my kindly take up this matter. It's a small matter, man.
Next week, 13th, my lord.
Tomorrow, or day after tomorrow.
Why?
It's
Sir,
my petition, my lord, my learned friend is on
Like,
behalf of this.
on last occasion, the petitioner showed so much urgency. And
Lord, I have actually, because my lord,
Today, I
I
have
could
no
not
objection
pay
for
the
adjournment.
challan, but today, few days back, my lord, I could pay the challan online, my lord.
Uh-huh.
That's why, my lord, they are happy now, they got.
You are stopped?
My
For what? For what reason?
No, my lord,
Overspeeding.
they are
Huh?
filing
Overspeeding.
over speeding, my lord. They, my lord, lots of defects are there, my lord. I will satisfy, my lord, that this was not in accordance with law, my lord.
Yeah, next week, what is there?
My lord.
Yes.
Next,
Tuesday, man.
On the prayer for adjournment made by the petitioner in person. List the matter in the next week. The petitioner in person submits that he has already paid the challan online.
an affidavit has also been filed, my lord.
Lordship,
Okay.
fix it, man.
I don't know. We have got a lot of matters. There's
Fine.
a problem.
Fine.
It'll come. It'll come.
My lord, lordship. Deeply
Right.
appreciate, my lord.
May I please, your lordship. Lordship, I beg to mention item number 11, lordship.
11.
11, lordship.
Yes.
This matter may be taken up after a week, lordship. I am for the petitioner, lordship.
Wait, who's for the respondent?
My lord, the IWT, lordship.
Yes, who's the counsel? Let the standing counsel come. You haven't spoken to him. Yes.
That is all, lordship. Lordship, I like to mention these are long pending cases, lordship, for listing.
Long pending cases. Give a
One
date.
for withdrawal and two for listing. Three cases are there.
Withdrawal we can do tomorrow. This thing so will take time. Unless it's a new case.
One for Friday and one for next Monday.
No, Friday. Matter is to it. We've got too many cases.
Lordship. Okay, lordship. I'll change the date.
Yes, change the dates. For withdrawal, you can fix for tomorrow.
Okay,
Yeah,
lordship.
similar, it's a matter, but urgent matter, my lord.
Huh?
Regarding operation of the bank account, my lord. Petitioner account has been fixed, my lord. It was listed on last 29/1, my lord.
Huh?
Matter was listed for admission on last 29/1. That could not be reached, taken, my lord. So maybe taken on for admission on Friday, my lord.
No. Give some date after 2 weeks. No, wait.
What the best to mention item 27, my lord.
27.
27,
Just
Lord.
check out, huh? The date. Ensure.
I need to file, obtain instruction, file reply, my lord.
And 27.
27, my lord.
27. Okay, you're going to file your,
Yet I've taken consent.
okay, arbitration.
Arbitration. There are some,
What is there?
my lord, some instructions, sir.
What? To what effect?
My lord, that certain reply is also given by the department to the arbitration notice, my lord. That has not been annexed by the petitioner, my lord. That the department will supply to me. my lord.
So what? Have you got the parawise comments?
No, my lord.
Then this is supposed to be the very purpose of having arbitration is for speedy resolution.
My lord, we fix a short date, my lord.
What
I have
short date?
spoken to the
You have taken
department,
so
my
much time.
lord. The extra copies were also not supplied, my lord.
No, last time also you have made some submission also. I think
My lord.
it is recorded.
My lord, extra copies. I have spoken to the department.
Look, it's a simple thing. If there is a dispute in terms of the arbitration clause, it has to go for arbitration. That's all. There's nothing. You don't even need your objection. Affidavit is not necessary. If there was no dispute, they won't be here. Then-
It's a short date.
List the matter when? Next week.
Next week, no.
List the matter on, give a date, Wednesday.
Next week.
Oh, no holiday. Valentine's Day. List the matter on 15. By which date Mr.
H. Gupta, my lord.
H. Gupta shall submit his objection, if any.
My lord.
In the event he does not submit any objection, the matter will be decided on the basis of the materials on record.
May I please,
Item 27, no?
may I please, Your Lordship. But with regard to item number 47,
Yes,
as per the instruction of the petitioner, my lord, I may be allowed to withdraw that.
okay. Mr.
P. Chaudhary,
P. Chowdhury,
P. Chaudhary.
learned counsel for the petitioner submits that he has instructions to withdraw the writ petition.
Contempt petition.
Withdraw the contempt, as the petitioner does not want to press the case.
Your lordship.
Mr. You are appearing? And the prayer of the petition's counsel is allowed. The contempt petition stands closed as withdrawn.
They please.
May I please? Your Lordship, I have filed one writ petition.
Huh?
I have filed one writ petition, as only just 2 days before I have been given an instruction to vacate the property.
To vacate the property.
And without serving a single piece of paper to me, either notice or anything.
Eviction,
Yes, Your Lordship.
whether this court, I don't think this is I think this is not
Bench.
I think it's a different bench has to go to eviction. Eviction will be, huh? Bench 5. This is bench 4.
Please, Your Lordship. Lordship, I beg to mention item number 6 of today's list with the concern of the other side, Your
Item 6, yes.
Lordship. Kindly adjourn for the day, Your Lordship.
Why?
Lordship, we need to file an IA, appointment of the prayer, Your Lordship.
What IA?
The interim prayer, Your Lordship.
Interim prayer. Just give me item 6. What is there? The only issue is the direction passed by this court was to be acted upon.
No, Lordship. We want to cancel the NIT and for the new NIT, Your Lordship. We want to resettle it, Your Lordship.
You want to cancel the NIT, but there is a court order passed in 4957 of
Yes, Your Lordship.
2023.
Yes, Your Lordship.
Then can this court pass an order against the order passed by a coordinate bench? What? Does it go what? Can this court pass? Can a single bench pass an order against an order passed in the same case? But, I mean, in the same subject matter, but in a different case. Can it do that? You wait, we'll see.
May I please, Your Lordship? Should beg to mention for listing of 3 similar pending writ petitions, Your Lordship, relating to non-payment of contractual dues, Your Lordship. Matter-
Pending matters.
Yes,
Give a date, give a date.
Lordship.
May I please, Your Lordship. Lordship, in supplementary item number 49, my lord, we have filed additional affidavit, my lord. It will be kindly call for me.
No.
Lord, I have another prayer for listing of a writ petition, my lord. It was
Huh?
prayer for listing of a writ petition, my lord. It was last listed on 31st of May.
Give after third week also, all after third week. No, we are too full.
Maybe similar pair for listing the case mail for pharmacy license mail. It's pending. for-
Pharmacy license?
Yes, sir.
Okay,
Public.
after that, we just. show.
But I have a similar prayer with.
Huh?
I have a similar prayer with respect to 2 individuals, my lord.
Please, my lord. My lord, I beg to mention for listing of a tender matter, just filed on yesterday, my lord. I'm begging for tomorrow, my lord.
Why?
My lord, the work order is likely to be issued, my lord.
Likely to be issued.
Yes,
When? Day after tomorrow?
My lord, it will be convenient, if it is convenient for this honorable court, for tomorrow, my lord, because
What is the matter about what work order?
my lord,
for
it's a
what?
tender matter and
Tender regarding what?
tender
Fishery,
regarding for
what?
construction of RCC slab.
RCC slab, just a
Yes.
slab, that's all, no building.
No building, my lord. RCC slab upon that drain.
Okay.
It's an municipal tender, my lord.
Okay.
Highly obliged.
May I please, Your Lordship?
Come on.
Lordship, I beg to mention item number 31 and 32, my lord. I am appearing on behalf of respondent number 3, my lord. Lordship, we have not received the instructions, my lord, from the seat corporation, my lord. We need some time, my lord. We'll file our affidavit in the meantime, my lord. We've taken the consent of the petitioner, my lord. With 2 weeks time, we can be granted.
Okay, right. Mr.
A.M. Sharma, my lord.
A.M. Sharma appearing for the,
Seat corporation, my lord. Respondent number 3 in both the cases.
for the
But a seat corporation, my lord. Assam Streets Corporation.
Assam Seed Corporation. Have you received Parawise comments?
We will receive, my lord. We have
We
intimated.
will receive is a different issue. When will you receive?
Maybe by tomorrow or the day after tomorrow, my lord. They will
Submit that he will be receiving Parawise comments within 2 days. He accordingly prays for how much time?
2 weeks, my
2
lord.
weeks time to file affidavit of opposition. List the matter on Monday. To list the matter on Monday. List the matter on Monday, on which date the counsel for the Assam Seeds Corporation shall inform the court as to whether he has received Parawise comments.
Obliged.
So you bring on that, if you don't have, if you have it, then we'll see.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention one
This matter pertains to non-payment of unpaid bills. Huh? Yes,
May it please the Lordship. I'd like to mention item number 33 for adjournment, Lordship. I'll be filing a rejoinder in the matter. I've received the opposition yesterday
your father?
and for the petition. I've already informed the other side.
Affidavit of opposition has been filed.
Yes, yesterday only I received it.
And what do they say?
There are certain law points which they've inculcated in.
What do they say? That renewal not required or not cannot be given or what?
Lordship, I have to go through the
You
petition.
don't even know the facts of the case.
Lordship, it is for resumption of the boring water supply unit.
Then what did they say? Why have
They're
they not?
saying that we have violated the rules.
Huh?
They are saying that we have violated the rules. We have not.
Violated the.
Yes, Lordship.
Okay, Miss
And Begum, Lordship.
N. Beckham, learned counsel for the petitioner. Prays for how much time?
1 week's time.
A week's time to file affidavit in reply. In as much as she has been given the affidavit in opposition yesterday.
Yes, sir.
List the matter after a week.
Much of.
My please, Your Lordship. Your Lordship, I beg to mention one writ petition for listing, Your Lordship, regarding settlement of Ferrygut, Your Lordship. Some urgencies there, Your Lordship.
New case.
No, your pending case, Your Lordship.
When was it filed?
Your Lordship, it was last listed on 24/1/24, Your Lordship. Any date in the next week, Your
Huh?
Lordship. Any date in the next week, Your Lordship, because the term is already about to end, Your Lordship.
Till July,
Yes, Your Lordship.
June,
No, Your March. Your Lordship.
March.
Yes, Your Lordship. Highly obliged, Lordship.
May it please. Lordship, I'm praying for listing of one read petition for admission.
Give a date.
May it please.
Eh?
Please, Your Lordship. Lordship, I would like to mention item number 21 of the daily list. My lord, item number 21. It
Yes,
is an arbitration petition, my lord. My lord, the parties look to settle the dispute amicably, my lord, out of the court. My lord, may give one chance for.
Your
them to
Lordship,
settle
actually,
the-
they have approached us.
oh,
They have approached us, but the settlement has not been arrived. So may I pray, it may be kept in abeyance, adjournment may be given for 2 weeks, till then if the.
okay,
talks are
Mr.
R. Sinha.
R. Sinha, learned counsel for the petitioner. And Mr.
B. Sharma.
B.
B. Sharma.
B. Sharma,
B. Sharma.
appearing on behalf of
P. Burwa.
P. Barwa, learned counsel for the respondents, submits that an out-of-court settlement is being attempted. Accordingly, list this matter after 2 weeks.
Deeply obliged, Your
My
Lordship.
lord, can it be after 4 weeks, my lord? They can be given a chance.
I don't know, I don't know,
If they have no
after
problem, my lord.
Okay, 3 weeks, Your Lordship.
3 weeks.
Oblige, my lord.
May I please, your lordship? I'm praying for listing this matter in any day of the next week.
Next is no, pending matter.
No, sir, listing.
Listing, there's a new matter, there is a old matter, there is a pending matter. What? Is it a new case?
Yeah.
You have filed it when?
There is no, I didn't remember
What is the case number?
number.
How can it be? Madam, there has to be a case number. It will be there in your form. No, sorry. You have to give the case number, what? Or the, otherwise, how are they going to list if there is no case number? Next, yes,
Item number 13.
13.
13, we have received parawise instructions, we'll file the affidavit. Consent of petition has been obtained.
Okay. Yeah. So have you spoken to the petitioners council?
Yes, I have spoken to. No,
Miss- Mr. D. Over. Learned counsel for the forest department submits that he'll be filing affidavit in opposition today.
No, we have just received 2 weeks,
Submits that he has received parawise comments today and will be filing affidavit within 2 weeks. Accordingly, release this matter after 2 weeks.
All right,
Just another pair, your lordship, today's item number 10 in the list may be passed over for 2 weeks.
What are you appearing for?
Your lordship, there's no, I am not able to communicate with the client.
Are you, have you signed the Wakalat Nama?
Oh, yes,
But your name, what is your name?
Preeti.
Huh?
Preeti Chauhan.
Preeti, your name is not here in the call list. Who is your senior?
R.S. Chauhan
Where is he?
and other court.
Court, which court?
Court number 14.
Court number 14. Let him come. We'll see. No adjournment.
May it please your lordship, you my lord pray for listing of 2 writ petitions for admission.
Get date.
Much obliged. May it please your lordship, I beg to mention for listing pending case lordship, last listed on 3/5/23 lordship.
523.
Yes, lordship.
It's a tender matter or what?
No, lordship, it's a area pending salary matter, agriculture department.
Give a date.
Lordship, day after tomorrow,
No.
lordship, next week.
You see, salary, pending,
Yes,
pending area salary,
Yes, lordship.
you can always be compensated. That is, so
Lordship, all the
urgency is not that
petitioners
much.
retired.
Huh?
All the petitioners are retired, that's why lordship. It's a-
Are retired, then where's the question of retired, area pending salary?
May I please, your lordship?
Lordship, I would like to mention item number 44.
Yes,
Yes, sir, go ahead.
okay, right. On the prayer for adjournment made by Mr. Your name?
Kolit. K. Kolit.
A. Kalita. K. Kalita. Learned counsel for the petitioner. This is the matter after
2 weeks.
2 weeks.
So my lord, I beg to mention item number 11, lordship. My lord, I have intimated my learned friend, lordship. My lord, this matter may be taken up next week, lordship.
Wait, let him, where is the council? This is the second time you're saying. Where is the council?
Lordship, I'm searching hard, but where she's gone, my lord. My lord, is still in there.
My lord, I am appearing on behalf of MD.
So, in item 11,
Yes, 11.
any objection? Or what?
Next week.
No, you are ready with the case.
My lord, in last occasion, my lord, oh, we didn't have any objection.
Where is the meeting minutes of 11, 10, 22? I think that will clear up everything. Correct?
My lord, we are not directed to file affidavit. My lord, there
Huh?
are senior advocate did not directed to file the affidavit, my lord.
So this order was passed in November and now it is February.
So we are not for that, we are referring for the transport department, my lord.
Where is Mr. Dinath? Huh? Where is he? Tell him to come. We'll see.
Notice may be issued, my lord.
Huh?
Notice may be issued, it is for contempt matter.
Why should notice be issued just like that?
But this, the commission of the contempt,
The order
yes,
where you are alleging contempt
Yes.
was issued when?
2014,
2014.
yes,
What is, now when did you file this contempt case?
that my lord in 23,
In 23.
yes.
Now, when in 23?
The
Which month?
Paragraph 5, 6 and 7, my lord. They were aspiring for payment, my lord.
Mr. Counsel, what about section 20 of the contempt of court act?
When the commission of the contempt
Yes,
is the knowledge within the knowledge. of the-
yes.
Yes.
So when did you give this copy of this order to them?
Yes, that immediately, my lord,
Immediately.
immediately.
In 2014, you gave
Yes,
it to
yes.
them. So now how many years have passed since 2014?
They were, my lord, statement I have made in the affidavit, my lord.
That what?
They say that we are preparing the bill and we will make the payment. And then, my lord, in para 5, 6 and 7,
Mr. Counsel,
23, they refused to make the payment.
where have they said that they are going to make the payment? Show me the
Yes.
document.
Yes. Document, my lord, the notice we issued on 26, 23, my lord.
Mr.
My
Counsel,
lord, they were to make the payment, my lord. They were to make the payment.
that they have got to make the payment, but then you cannot come in a contempt after 9 years.
That is, my lord, the law says when the contempt comes to the knowledge of the petitioner, my lord.
Oh, come to the knowledge of the petitioner. What were
Yes.
you doing for 9 years then?
That we are approaching, my lord. They say that the paucity of fund, my lord, they could not pay.
You file a writ petition again after.
My lord, they say that they are, because of the paucity of fund.
Where have they said that?
Yes, that I have stated in para.
No, your stating will not do. Right.
My lord, the affidavit we
Heard,
have
Mr.
submitted.
Huh?
We have submitted by affidavit. Let them deny, my lord, simply by the notice, let them deny that they
Heard
have not
Mr.
made
J.
any approach.
Sharma, learned counsel for the petitioner. I'm dismissing your case. I'm closing it. Contempt is between this court and the contemptor. Not, you have got nothing in between. You have got
That
nothing to
is
say.
initiated by the petitioner.
You
also,
can
my lord.
file a writ petition. That much, that is not a problem. But we cannot allow you to file a contempt petition 9 years after the order of this court. That is, have you read section 20 of the
Yes,
Contempt of
yes,
Court Act? Then,
Yes. That is there, my lord. It
then
is
if it's there, then well,
from the date when the contempt is
Yes.
alleged to have been committed.
and then you gave them you gave them the order in 2014 itself,
Yes.
and
But
they have not given you till date.
They were giving assurance that we are making payment, the paucity of fund they could not pay.
There is no document to that effect out here.
Document, how the document, my lord, it is with them, my lord.
Then within 1 year you should have filed.
That is
You
not-
wait for another 20 years now. They'll keep on waiting for their assurance. Why you suddenly filing? If you were satisfied with their oral assurance
Yes.
for the last 9 years, you
Then
wait for
I-
another 20 years.
Because of the COVID also, 2 years already been passed.
Maybe, but then this is the law, Mr. Counsel. I'm bound by the law.
But we have.
Then
no-
otherwise, if we allow your case,
We have.
then
no-
other cases will come. 50-year-old cases, 40-year-old, 30-year-old cases will come. Then what to do?
That case was allowed by Supreme Court, my lord.
Right. Heard Mr. J. Sharma, learned counsel for the petitioner. The instant contempt petition has been preferred by the petitioner, alleging violation of the direction contained in the order dated 21/2/2014, passed by this court in WPC number 933/2014. This court, in the order dated 21/2/2014, had directed the respondents to consider the case of the petitioner in the light of the judgment of this court. In light of the full bench decision of this court in Shamsher Ali versus State of Assam and others, 2008 4 GLT 1, in respect of the claim made by the petitioner that his unpaid bill of rupees 55,84,040 had not been paid. Unpaid contractual bills had not been paid. The petitioner's counsel, the petitioner's counsel submits that the petitioner had immediately given a copy of the order dated 21/2/2014 passed in WPC 966/2014 to the respondents for compliance. Full stop. However, despite their assurance to comply with the order, the same has not been complied with till date. Full stop. Accordingly submits that contempt for proceedings should be drawn up against the respondents. Full stop. As can be seen from the facts of the case, enumerate as submitted by the petitioner's counsel and enumerated in the contempt petition, the petitioner has filed the contempt petition on 2/8/23 for willful violation of the order dated 21/2/2014, that is after 9 years. Full stop. After 9 years of the order passed by this court. Full stop. Next para. Section 20 of the Contempt of Courts Act, 1971 provides that no court shall initiate any proceedings of contempt, either on its own motion or otherwise, after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. Full stop. In the present case, though there is no, in the present case, though there is no time limit provided in the order dated 21/2/2014, passed in WPC 966/2014, the order, it is implied that the order dated 21/2/2014 should have been complied with within a reasonable time limit. As a reasonable time limit cannot encompass within it a period of 8/9 years. This court is of the view that the present case is hit by section 20 of the Contempt of Court Act, 1971. Accordingly, the contempt petition stands loose.
Liberty.
Huh?
Liberty for press with petitioner.
Liberty is always there. Liberty is always there. You could have prayed in the first place. I do not have to say all this.
But that could be added, my lord.
What you do is, instead of that, then you pray that you will not press this contempt and that you will file a appropriate, then I will allow that. That may be better. Yes. Right, Mr. S. Sharma, Mr. J. Sharma, learned also for the petitioner submits that. That instant counsel, so is there already. Then you write, he prays that due to the delay in filing the contempt petition, he would not like to press the contempt petition. However, he may be given the liberty to file a fresh writ petition. Full stop. The prayer of the petition counsel is allowed. The contempt petition stands closed as withdrawn, with liberty as faithful. You file it because it's so simple. Within the first day or we will allow it. First, second day. And then you can wait and then you file a fresh writ petition. A contempt petition. Otherwise, this will not be correct.
Businessmen, my lord. They're doing their business in the market, my lord, run by Daboka Municipal Corporation. My lord, Daboka Municipal Corporation, my lord, in the year of 2017, my lord.
Huh?
Deficit could pay, my lord, order that
What?
deficit could was to be paid, my lord.
Yes, paid.
Yes, paid.
Yes, my lord. My lord, as per order to 1811, my lord. He was prepared to produce some documents regarding evidencing whether he was surplus elected to him or not.
Whether he was
Surplus elected in his name or not.
allotted in his name. Yes.
As my lord, kindly see, page 17, my lord.
Yes.
My lord, is the Bharatiya Bandobasti Patra. There is a, my lord, tenant settlement letter, my lord, issued to the petitioner, my lord. They are petty businessmen, my lord, only a portion of land, my lord, they have been using, my lord.
Huh?
Only portion of land of the market, my lord, they have been.
This
using.
page 17, where is the English translation?
Yes, my lord. 16, my lord.
16. So 16 shows that this is an agreement, tenancy agreement
Agreement, my lord.
for 1 year.
Only for 1 year.
From 1st
Every
April
year-
17.
Every year, my lord, can you see, they are before, my lord, page 13, that is 12, cancellation. Every year they paid, my lord. In the year 2017, my lord, municipality proposed to construct some room, my lord. And they,
Mr. Counsel, look, let us be very
my-
clear. Your page 16 talks of agreement from 1st April 17 to 31st March 18.
18, my lord.
Then after, subsequent to 18, 19, 19, 20, where is this?
My
Where is
lord,
that?
can we see page 18, my lord.
Page 18.
18, my lord. Daboka Town Committee, my lord, received from so and so, son of so and so, rupees 50,000 in what? 50,000 only on account of Vita allotment fees.
That is for
They
this.
took Vita allotment fees, my lord, they have not allotted the Vita. And my lord, since then, my lord, they are approaching, my lord, the authority, my lord.
So how much have you paid fully?
Total, my lord, 80,000. First
Yeah.
50,000, then 30,000.
Where
my
is
lord.
that 30,000 car receipt?
No receipt has been given, my lord. I stated in my petition, my lord, that they did not.
Any
receipt, my
shop
lord.
number, any room number? Was there any
No,
shop number,
no,
any
my lord,
room
no,
number? No.
Open
Open area.
Open
Open
area.
area.
And they took.
So they allowed you to, so they gave you they allotted you the open area and then you constructed a,
No, they constructed some rooms, my lord, there.
okay, they constructed.
And they proposed it to give us 50,000 first. And now we will allot you a room there from my lord. And
So-
room were now already
Constructed. They have not
They
allotted
have
you.
Not allotted, my lord.
The case my lord notice may go, my lord.
Have you have filed affidavit or representation also?
Yes, my lord, kindly see, my lord.
Okay, anyway, right. Heard Mr. J. Atia, learned counsel for the petitioner, who submits that the petitioner was allotted space for running what? For
running a small cloth market.
running a
Cloth
slot
shop, cloth.
cloth shops, cloth shop. Full stop. Thereafter, he was made to pay Rita allotment fees, RITA, of rupees 50,000 on 29,570. Full stop. Thereafter, another 30,000 was paid by the petitioner, for which no receipt was issued by the Dabaka Town Committee, municipality. Full stop.
Which they proposed to issue 80,000 receipt, my lord. They took 50,000 receipt from me, my lord. And I keep one photostat copy with me.
Full stop. Next paragraph. The petitioner's counsel submits that in the land allotted to the petitioner, the respondents have constructed shops.
Shops, my lord.
Shops. Have no. I have constructed a shop. Have constructed a
RCC shop,
RCC shop. Full stop. However, the same has not been allotted to the petitioner despite rupees 80,000 having been taken by the respondents. Issue notice returnable in 4 weeks. Mr.
M Setia for respond number 1 and 2.
M. Chettiar accepts notice on behalf of response number 1 and 2.
Yes.
What about 3 and 4?
My lord, Sam and
Chief Executive Officer.
Dabaka municipal board, my lord.
Who?
Notice will go, my lord.
No. Petitioner takes steps for service of notice upon the response number 3 and 4 by registered post with AD within 3 days. List the matter after 4 weeks. Right. Heard Mr. J. Sharma, learned counsel for the petitioner, to submit that the order dated 17/3/23 passed in WPC 4062 of 22 has not been complied with. Issue notice returnable in 4 weeks. Petitioner to take steps for service of notice upon the respondents by a registered post with AD within 3 days. List the matter after 4 weeks.
Okay.
But in this case, I have taken instruction. There are 2 cases, but wrongly they have supplied this and they did not. They
Huh?
long listing. So I may be allowed to withdraw with liberty to file a case.
Mr. K. Halloy, learned counsel for the petitioner, feels that he may be allowed to withdraw the writ petition with liberty to file afresh. Mr. M. Chetty appears for the
Respond number 1.
point number 1. Whereas the petitioner's counsel is allowed, writ petition dismissed has withdrawn, with liberty as paid for.
Much.
5 minutes, just for the timing, Mr. Goswami will 10 minutes, just for the timing, just for the. Just.
Malad, let me after some time because I want to do eye doctor, Malad. I have some medicine put in my eyes.
Okay.
So that is blood me. So
Okay.
tomorrow there is operation.
Okay. So when do you want?
After 2 weeks.
Okay, right. Mr. R.P. Sharma, learned senior counsel for the petitioner, prays for adjournment on the ground that he's got some eye problem, which is going to be operated upon tomorrow.
Okay.
List the matter after 2 weeks.
All right.
Okay, right. Mr. D. Gogoi appears for the forest department. List the matter after 2 weeks.
6.
Please a lot.
So basically, Your prayer here, what is your prayer?
My lord, to re-tender again, your lordship, but we have missed out a small portion of lines in the prayer, your lordship, for the interim, your lordship.
No,
we
no,
need to
no,
find-
no, you please come to page 22. Where's the question of retender? How can this court do that?
your lordship.
You see, what has happened is that you were approved for the tender.
Yes, your lordship.
However, that was challenged by the respondent number 4 in another writ petition.
Petition, your lordship.
And that writ petition has been disposed of by this court with a direction that the respondent authorities are directed to revisit the matter of settlement once again on the basis of records and to arrive at a decision on the matter of settlement of the market. The entire exercise shall be completed within a period of 1 month from today.
Yes, your lordship.
So this order was issued on 16/10/23. This is a valid order.
Your lordship. But my client did not came into your notice, your lordship. I have mentioned in
Huh?
paragraph number 8, your lordship.
Paragraph number 8.
Yes, your lordship.
You were not aware of this order. For what?
No, your lordship, we
Just
have
a
not
minute.
been informed. We have not been informed.
You're not informed about what?
We were not informed regarding this order, your lordship. We came to know from
So
some
you were
other
not
person.
you were not a party to this case.
No, your lordship.
So in that case, what is to be done is you file a review.
Lordship, you
In-
party.
That's what.
Respondent number 4.
Number 4. Yes, you are a party.
Oh, yes, your lordship.
Then how can when a court has passed an order, a coordinate bench, when it has passed an order with regard to the same subject matter in issue, can this court, a coordinate bench, pass a different order in a different case?
No, your lordship.
Then
But the petitioner came to know secretly regarding the settlement of the market, your lordship.
what settlement?
I have mentioned in my writ petition in paragraph number 8, your lordship.
Madam, please read your prayer. Please read your prayer.
Yes, your lordship.
What is your prayer?
For quashing of the order, your lordship,
What order? What order you want to quash?
of this order.
You want to quash the order? Which order?
16, 10.
You want me to quash a coordinate bench order? How can I quash?
Yes, your lordship.
You go to the division bench, madam. You have to go to the division bench.
Your lordship.
You withdraw this writ petition. It has to be dismissed.
No, your lordship.
Huh?
Withdraw.
Yeah. Okay, right. Miss
H. Teranki, your lordship.
huh?
H. Teranki.
H. Terampi.
Teranki.
Terangpi. Learned counsel for the petitioner feels that she may be allowed to withdraw the writ petition. That's all.
Yes.
Miss R.B. Bora appears for the BTC. The petitioner's counsel is allowed. Writ petition is dismissed as withdrawn. You have to go to the division bench,
Yes,
madam.
your lordship.
Right now?
My lord, may I kindly peruse the last page, my lord, page 49 of my petition.
Yes. Page 49.
What you banding instructions regarding this?
What instructions? What instructions do you want?
The department said regarding this.
No, this is the department send. The issue is this.
Okay.
Only thing you can take is whether this is a fabricated document or not. That's all.
Lordship, there
Huh?
still needs some.
Okay, with that, let them take only that.
Lordship.
Right. Heard Mr. A.R. Bhuyan, learned counsel for the petitioner who submits that the contractual dues of the petitioner amounting to rupees 19,97,626 have not been paid by the respondents, despite the letter dated 28, letter number G-5/CC-085/2023-24/5076. I'll mention it one more. Letter number G-5/CC-085/2023-24/5076. Dated 28/9/23, issued by the executive engineer, PWRD, Karimganj North, Karimganj South, and Badarpur Territorial Road Division, Karimganj. Having stated as follows. Page 49. From subject to here. Next, Mr.
Lordship, that we are on behalf of Big Gogoi.
Mr. B. Gogoi, learned counsel for the home, for the PWD, submits that he will obtain instructions as to whether the letter dated 28/9/2023 is a fabricated document or not. Only that is required.
I prefer a date, my lord.
List the matter on, give a date.
Oblige.
Response number 2 has issued a tender lordship at page 25. And pursuant to this tender, we have, I have, along with others, participated in the tender process
Tender process for what?
for different works of hundreds.
Different works,
schemes.
okay.
Lordship will define the work which was located where.
But the different, but which work, so which particular work are you talking about?
Yes, Lordship.
Did you? Because there are a number of work.
There are a number of works. My work is scheme number 18, Lordship.
Page?
Scheme number 18,
Scheme number 18.
Lordship.
Scheme.
Scheme. There are different schemes are there.
Yes, let us see what is scheme number 18.
Scheme number 18, Lordship. Construction at page 27, Lordship. Down below.
Yes,
18, Lordship. Construction of Rhine Canal of Kanera FIS under PMKSY HKKP for the year 2021 and 22. Now, Lordship. the
this
pa-
is scheme number 17 and 18. You are for which one?
for
18.
18.
Okay.
Now, Lordship, the Financial Bid Evaluation Committee meeting held on 21/7/23 has declared petitioner private response number 5 and another
Where?
as LOI
Page.
at page 195. Page 195. Vidinta Kachari is the petitioner, Lordship.
Huh?
Vidinta Kachari is the petitioner who has been declared L1. Parimal Devnath, he is not the party here. Jitupal Deka, he is the response number 5. He was also declared L1. Now, if
So
the
L1, so 5 is declared L1.
3 has been declared
3
L1.
persons are declared
declared
L1.
L1. Now, if your Lordship comes to page 46 and 47,
So
of
the
of the
page
tender.
46, wait a minute. So who has been awarded the contract?
that response number 5,
5.
who has no work experience in the irrigation department. I've stated, and I will show
The page?
page 46 and 47, Lordship. States that 29 award criteria, Lordship. Roman 3,
Yes.
the package may be subdivided during award of contract. Now, if your Lordship comes to the 29/6, Roman 6, at page 47. In case more than one bidder stands L1, as per the comparative statement of financial bid, the bidder having higher annual turnover during 3 previous financial years, higher value of single work order in similar nature of work, and higher number of equipments proposed to be used in the work shall get preference in award of the contract. The weightage of the annual turnover shall be considered as 40% for single work, and 35% of the equipment shall be considered as 25% for comparison of bids and selection for award. Now, Lordship, if I take your Lordship to page 95. This is my solvency certificate declared by the bank, State Bank of India, at page 95.
Yes.
This is to certify that Mr. Vidanta Kachari of village so-and-so district so-and-so is a valued customer with good financial standing and presently maintaining SBI account bearing number so-and-so with this branch, and this transaction in the accounts are satisfactory. In this contract, if the contract was named so-and-so under so-and-so is costing rupees 1,72,34,800 is awarded to the above firm, we shall be able to provide overdraft credit facilities to the extent of rupees 52 lakhs only to meet their working capital requirement for executing the above contract.
This certificate,
Now-
they will give to anyone.
Lordship, now if your Lordship comes to page 97, this is the
Yes.
financial information of 3 years of the petitioner.
This is your financial information.
Lordship,
What about the financial information of L5?
Yes, yes, yes. Here is.
Point number 5.
Now, response number 5, financial information. At page 149. This is the
Yes.
financial information.
Yes.
For the year 2019-20, 86 lakhs, 86 lakhs 88,790. For the period 2021, 22 lakhs 75,800. For the period 21-22, 48 lakhs 29,400.
And where is your financial
Yes.
information?
Lordship, at page 47. Oh, 97, sorry. I'm much more higher. At page 97, Lordship.
But that is only one criteria. Then you need higher value of single work order.
Yes. Now, if your Lordship comes to the work done by me at page 116. All are in the irrigation department, Lord. At page 116.
Yes.
Number 1, Lordship, I have the work value was 74 lakhs 97,227, 100% physical progress. Then number 2, 99 lakhs 8,900. 9 lakhs 98,998, 100% physical progress. Then third one is 9 lakhs 98,900.
What about the respondent number 5?
Yes, Lordship. $178 to $180.
178. Yes.
180, Lordship. This is he has constructed in the PWD, not in the irrigation department. Work value at page 180, number 1, work value 12 lakhs 57,857. Number
see,
2,
So you see, Mr. Council, one thing is,
Lordship.
what you showed me was with regard to the work done by you in one division.
Lordship, in irrigation.
We do not know what kind of work he has done in various other divisions and
Only in the
departments.
PWD, Lordship.
Huh?
Only in the PWD.
Where does it say that only the
Yes,
PWD? is-
here, yes, Lordship, I have stated in my,
Then, another thing is that higher number of equipments proposed to be used.
yes, Lordship.
How many number of equipments are you proposing to use?
I have 10 numbers of equipments, Lordship.
Where is that?
Lordship will find at page 127, 28.
And where is his number of equipments that he's going to use?
Page 163. Sixty-three, excavator, welding machine, DG set, mixer machine, water pump, 0.5 HP, tractor with trolley, truck, Belsa, Tagri, Kudal. These are the lots of that. I am much more in the higher footing, Lordship. I am L1, class 1B contractor, and he is class 1C contractor, Lord. And the Indian order at page, and I have also filed several representation, Lordship, at page 189.
Yeah, 168 according to you, according to his equipment.
Yes, Lordship, 168.
No, not 168. It is where is that thing? Where is his equipment? Page
Equipment at page 1.
of the respondent number 5.
Respond number 5, page 63 and 64. But work order was issued on 25/9/23, but till date he has not executed the work because he has no experience in the irrigation department. Therefore, Lord.
I don't know now. We don't know. We'll have to
Lordship,
see.
Indian order at page 192.
25/9/23, and you have put that to challenge now.
No. Now only on 12/1/24 I have came to know because after that, Lordship,
Whatever you came to know that 12/1/24,
yes.
but then he's been having that work order
No,
with
if
him.
your Lordship comes to 195,
We issue notice, that's all.
Lordship, if your Lordship comes to 195, Lordship, for a moment. The order detail, 12/1/24, last line, Lordship, above last line, lowest quoted rate 10% below quoted, serial number 1, 2, and 3 are accepted. Work order of rupees 12 is allocated to G2 Deca at the accepted rate on 12/1/2024. Then I filed a repetition, Lordship, which was
Where do you get 12/1/2024?
Lordship, down below, signature verified, digital signed by Sense of Bushmatari, 12/1/2024 date.
Anyway, who
Lordship,
is appearing?
I'm praying for a status quo, Lordship.
No, these
Lordship,
are
because he has not executed, I've stated it paragraph 17.
these are development works.
Lordship,
At the same time, Lordship, we see the minute, sir, it seems to be a cartel.
Huh?
It seems to be a cartel, my lord. Lordship will turn to page number 115, 195. Every person has the same number, same amount. All three. Each and every person knows each other, each and every person knows.
No, but this cartel, this cartel is this cannot be a cartel. Cartel is not like this. Cartel doesn't work like that. Cartel, how it works is that there'll be 3 different rates. Then the first one, he will withdraw. Then the second one, it will be given to, then the second one might withdraw also. So it have to be given to the third one or it will be given to the second one. So there'll be a difference in the rates.
And-
Out here, there's no difference in the rates. There's no cartel.
each and everyone knows the others rate, same, identical, all identical, three.
No, that is the different thing. It happens
At
sometimes.
the same time, my lord, the work order issued on 25/9/2023, long in the month of
That
September.
is what, that
Not
is,
to issue
that,
notice, along with the
yes.
Justice Service.
We cannot issue status quo, man. This is a, these are different schemes.
195, if your lordship comes to, I am placed at serial number 1. Why is the serial number 3, who is a class 1C contractor? And I am a
We
class
do
1B
not know,
contractor.
we do not know.
Yes, I have elected.
You are not the authority to select. It is their money.
Lordship,
We have to, we
there
have to,
should be a transparency in the selection law.
correct. So let us not condemn them unheard.
Because of the imperial order, work order was issued on 25/9. And by 12/1/24, he was, the respondent number 5 was asked to go ahead with the work. But till date, he has not.
We do not know. That is what
Yes,
you
I
say.
have stated, lordship. I have stated.
You are,
There 18, I have stated.
whatever you have said does not mean that it is the gospel truth.
Lordship, I have stated on oath at page.
And supposing tomorrow they say that what you have stated is wrong, then what does this court do?
Therefore, lordship,
It believes
there
you
could be a status
because
quo.
you are more handsome than him or what?
Therefore,
Huh?
lordship, I am praying for your lordship for status quo, lordship. If he has executed was, then okay, fine.
We can have the interim order decide the game.
Okay, let there be a Justice Service to the respondent,
Justice, you take
to
justice.
the private respondent.
Lordship,
Heard
that-
Mr. R. That, learned counsel for the petition, who submits that the petitioner had taken part in the, what is that, what is that, the tender notice, where is the date?
Page 25, my lord.
Page 25.
Page
Had
25,
taken part in
4
the,
February 2023.
had taken part in the tender number CHDI/ET/2022-23/9, comma, invitation for bids, bracket IFB, dated,
4th February.
where do you get that?
That,
Down below, my lord,
down below.
right hand side. 4
Dated
February.
4/2/2023. Issued by the council head of the department irrigation, comma, BTC, pertaining to different works of 100 new SMI schemes under PMKSY, new SMI schemes, bracket BTC, bracket close, under PMKSY, bracket HKKP, bracket close, for the year 2021-24. Bracket in 24 numbers of groups. In page 25 it is there. Next paragraph. The petitioner's counsel submits that the petitioner who had taken part in the bid, in the tender for construction of, who had taken part in, taken part in the tender for scheme number 18, comma, that is for construction of lined canal, LINED, lined canal of Bainara FIS and the PMKSY HKKP for the year 2021-2022. Page 27, it is there, huh? The petitioner, comma, respondent number 5 and another person were declared to be L1 in the selection process. So, however, the respondent number 5 was allotted the work order
Page 195. Or, sorry, at page 192.
was allotted the work order
On 25/9/2023.
on
25/09/2023.
25/9/2023.
Lordship will refer that letter also, 12/1/2024.
Huh?
12/1/2024, by which the respondent number 2 has again asked him to execute the warrant. At page 195.
In violation of, where is that provision you were saying?
Lordship. Page 47, Lord.
In violation of, in
Clause number
violation of
29,
clause F, no, clause 28,
29,
29,
6.
Roman 6
at page 47.
of the
Of the tender.
IFB, of the IFB. Comma, which provides as follows, page 47, okay, in red. The next para, the petitioner's counsel has stated that the petitioner has a higher annual turnover for 3 years than the respondent number 5 here. Comma, besides having higher value of single work orders in similar nature of works. Full stop. The petitioner has also got a higher number of equipments for the work than the respondent number 5. Full stop. Further, the petitioner is a class A contractor.
Class A B,
Class
A B, within bracket-
AB, A
within
bracket B
bracket B,
contractor, while the respondent number 5 is a class C contractor.
class 1C.
Class 1C. Okay, he's 1AB.
His
AB.
petitioner is class 1B. B. Not
Class 1B. Oh,
1B.
class 1B, not AB. Class 1B and and the respondent number 6, class 1C.
Yes.
Full stop. Issue notice returnable in
8 Lordship. Can it be on
returnable in 2 weeks. Returnable on 26 February. Mr.
As well. And we have for all.
F. Bora,
1, 2, 3, and 4.
accept notice on behalf of response number 2, 3, and 4.
1, 2, 3.
1, 2, 3, and 4.
1, 2, 3.
Petitioner will take steps for service of notice upon the respondent number 5 by registered post with AD within 2 days. Full stop. In addition to the above, the petitioner shall also serve notice upon the respondent number 5 through dusty service and file affidavit of service thereafter. List the matter on so and so,
the interim may be considered the next.
comma, on which date the interim order may be, the prayer for an interim order may be considered. All right.
May I please, Your Lordship? Now, petitioner in this case is a mining permit holder for a period of 2 years, with effect from 6/7/2023.
From 6/7/23 to,
6/7/23 for a period of 2 years,
so basically till 5/7/25,
up to 25.
then
My lord, after taking possession of the Mahal, my lord, due to some health issues,
health
he
issues.
took assistance of respondent number 5.
It took assistance, how?
Of respondent number 5.
Was there any agreement between you and respondent number 5?
My lord, some understanding that he. will
Some
do-
understanding, oral understanding,
Oral.
oral
written also,
understanding.
my lord. Then,
Oral-
my lord, then, my lord,
oral.
after that.
So there is no written document between you and the
No, no.
respondent number 5.
No,
All oral
thereafter-
understanding.
Thereafter, my lord, what happens, taking advantage of his absence, their restaurant number 5 is operating the mall and taking my lord,
So,
some illegal.
earlier, you had allowed the respondent number 5 to operate the mall.
Not allowed, my lord. My people are engaged there,
Ah.
but he will look after. people.
Really?
But, my lord, but, my lord, problem is this, now he is creating problem. So I have submitted representation before the DFO as well as the principal chief conservator of forest to see and restrain him that he is unauthorized person.
You, if you unauthorized, file FIR, police.
Police I have
When there, my lord, I have said it, my lord, police, when the police there, I cannot do anything. You go to your officer, say the controlling officer, they will do to everything. So I have submitted representation. my
You
lord,
can
that
file
needs
a,
to be
you
considered.
can file a case under, no representation business. You can file under CRPC, you can file to the jurisdictional magistrate. File a complaint if police is not doing anything.
That was not done,
Under
but police
CRP.
station, we have one there, my lord, police station, we have
Maybe
one. But
if
police
the,
station did not receive our complaint. my lord.
so, if they do not want to register your FIR, have you filed a FIR?
FIR, we went there, my lord, police
Yes.
station, but police station did
Where
not
is your
receive
copy of the FIR?
copy of the FIR. I have.
You filed?
I'll definitely file.
Huh?
I'll definitely file by additional affidavit.
Huh.
Copy of that.
No case,
Or,
no
my lord,
case.
at this stage, my lord, I am praying only for another issue is there, my lord. That after taking position, my lord, I have seen that area was heavily silted.
Huh?
The entire area was heavily silted. So I have submitted representation that to make an inquiry, physical inquiry, and pass the appropriate order, my lord. That prayer is also there, my lord, that is page 60, my lord. So both the representation may be considered, that is my limited prayer, my lord, at this stage, my lord.
And there's a specific clause at page 30, my lord. He can
30.
sublet. Page
I
30,
am not submitting, my
26,
lord,
which is contrary to my lord, page 52. He enters in an agreement.
no agreement, my lord. Officially, no agreement, my lord.
Page 30,
30, my lord, subclause, there's a clause 26,
page 26, yes.
page 3, 30.
The permit holder
Shall not, my lord, just
shall not,
sublet or transfer.
26, my lord. 30.
the permit holder shall, no, it does not say.
Assign,
Shall
assign,
not, my lord,
shall not,
because-
my lord.
Shall not
assign.
assign,
Shall not assign.
sublet or transfer the permit to any without obtaining. Okay, so that is that. Huh.
Now page
That was
52.
never done, my lord.
Now page 52.
52. It indicates some kind of agreement was signed.
You know, he's saying no. Let him file the FIR against the police. It's
Well-
not here.
My lord.
Regarding the other prayer, my lords, when a tender is floated, a person has to visit.
Huh?
A person visits the area, he on his own satisfaction, he floats, goes
Correct,
for a
correct,
trial.
correct. That is no ground.
And there's a mining plan also been, which has been given by him, prepared by him and my lord, submitted. My lord. So
This is to Deepak Das. Who is Deepak Das?
respondent 5.
Oh, notice who is Gopi Das.
Petitioner.
So, Mr. Counsel, you are telling a lie to this court.
My lord.
You are telling a lie to this court.
No, my lord, agreement.
Notice on deed of agreement.
Understanding was there, my lord. That is the understanding.
Mr. Counsel, please,
Only for
please,
assist.
please.
Well.
Let us not insult each other's intelligence.
My lord.
It says here notice on agreement, on deed of agreement. Deed of agreement can never be an oral agreement.
My lord.
Deed of agreement dated 18/7/23.
Yes, my lord.
Then, when is
Deed of
that?
agreement means that is the understanding, my lord. That's to look after them. I will produce the deed of agreement, my lord. Let me my
No.
opportunity to produce that, my lord.
You're hiding facts. You're
No,
trying
my
to,
lord, I
you're
am
trying to
hiding, my lord.
circumvent.
That is why I am annexing the documents, my lord.
But your pleadings are not in accordance with your document. Your,
Documents, I
your,
have
your,
stated, my lord. I have stated that I will produce the documents, my lord. I have stated. I have stated, my lord. Lordship will kindly see.
just now I asked you very clearly whether you had an oral understanding. You said yes.
No,
I
no.
said, where was the
Written is there, my
agreement?
lord. Written is there. I have stated, my lord. Lordship will
You
kindly see.
cannot twist,
Paragraph, my lord.
heard
Page
Mr.
number-
Jay
page
Sharma.
number 9, my lord.
Learned counsel for the petitioner. Who submits. There's no case.
No, no.
You
Lordship will
cannot-
kindly see page number 9, my lord. I have stated that petitioner takes weeks of the honorable court to produce the
I
state
heard Mr.
understanding.
Jay Sharma, learned counsel for the petitioner. You can go to division bench.
My lord, then, my lord, I will be liberty to file the affidavit, my lord, FIR in the police station.
You file it. You don't even have a copy here.
I'll file.
You file.
I'll file it.
Mr. Jay Sharma, learned counsel for the petitioner, prays that he may be allowed to withdraw the writ petition with liberty to file an FIR against the respondent number 5
My lord.
before the
Concerned police
concerned
station.
police station. To stop. Mr. D. Gogoi appears for the forest department. On the prayer of the petitioner's counsel, the writ petition stands dismissed as withdrawn. Full stop. The prayer for The prayer for filing a FIR before the concerned police station is always open to the petitioner. If so advised.
My lord, all right.
Item 48.
Lordship has already heard this matter, my lord. On the day before yesterday, my lord. Lordship speaks for orders, my lord.
Okay. That is,
Clause 10 matter.
huh?
Clause 10 matter, my lord. Clause 10 of the,
Okay, yes. I don't remember fully. The thing was that, clause 10 said that it has to go to the highest bidder.
Yes, sir.
clause 10.
Provides that the highest bidder should be given the settlement.
3 days time.
If he has not given his documents in the
except
tender.
Earnest money and court fee.
Huh.
If any sort of document, he will have 3 days for fulfill the submit the documents, my lord. That is the clause 10, my lord. And in this case, my lord, initially.
Let us see clause 10.
My lord.
That is, my lord, page 26, my lord.
There is an envelope, I think, in my yellow envelope. Yeah, that.
Page
Page-
26, page 26 of the petition. Clause 10. May I read, my lord? The tender for all Bazar Ghat, Min Mahal, Pond offering highest bid price will be considered for settlement. If the tenderer offering highest price does not enclose the relevant papers and documents except court fee and earnest money, he or she will be given a period of 3 days for submission of such papers and documents. And if she fails to submit the papers and documents within the specified period of 3 days, his or her tender will be cancelled and his or her earnest money will be remain forfeited, and the next highest bidder.
What is this relevant papers and documents?
My lord,
It is the relevant papers and documents. Do you mean that that is which is not a part of, which is not reflected in the tender notice?
no, my lord.
It's beyond that.
No, my lord. In the tender clauses, my lord, there are some certain documents.
Yes.
If suppose, my lord, for example, my lord, tax clearance certificate or caste certificate.
They are not there.
Suppose he didn't submit it with the bid, my lord, he will have 3 days time to submit it for the highest bidder, my lord. That was clause 10, my lord. And clause 10 was specifically challenged in the court, my lord. That was also filed appeal by one petitioner, and our division bench, my lord, told that as that petitioner, that clause 10 was not challenged before participating, that the writ appeal was dismissed, my lord, on that ground. I have submitted that judgment on the last date, my lord. WA 395 2022, my lord. I've submitted that judgment, my lord. So in the present case also, my lord, our defense is that.
Yes, sir.
Yes, my lord. Relevant paragraph 10.
Okay. So that is your case.
Yes.
Now,
And in the present case also, my lord, initially he was settled, my lord, as page 86, my lord, medicine, for the repetition. Page
in
86.
the present case, it was settled with him
Yes.
because clause 10 had been stayed.
Yes, in another case,
Another
which
case.
was withdrawn by letter only.
I am the highest bidder.
Not highest bidder. He filed this case, my lord. But another, sorry, my lord. Another bidder was challenged that case, my lord. And later on that was withdrawn, my lord. And stay was withdrawn, my lord. Already that withdrawn order also I have submitted on the last day.
Why are you here?
Lordship, I have filed WPC page 88, Lordship, WPC 4757 2023, containing that I am the highest bidder, and accordingly the settlement of the petitioner was cancelled. Settled.
Okay. Are you a party here?
Yes, he made party, my lord.
Respondent was
So you are Mukhtar Hussain. You are the third highest bidder.
Yes.
You are not the first, you are not the highest. What have you got to say? The petitioner bid is how much? What is this?
1 crore 52 lakhs.
No. Fourth highest, fifth highest, how much? What?
1
Fourth.
crore 52 lakhs.
Fourth highest, fifth highest. I'm not talking about the amount.
Yes. Petitioner fourth highest.
Fourth highest. No?
Highest bidder 1 crore 80 lakhs per year. Second highest bidder 1 crore 71 lakhs. Third bidder 1 crore 70 lakhs. And petitioner 1 crore 52 lakhs.
Okay,
Use
so
different
we are not concerned with that.
Yes.
So now, your case is this WA. Okay, then now, your case is what?
Just 1 minute, one line, my lord.
Yes.
Page 86, 186.
Page 86, yes.
That is also my one ground, my lord. Initially, when he was appointed, my lord, given the settlement, my lord-
Shall depend upon.
Yes. That part, my lord. That last paragraph.
I don't think this translation is correct. However, this settlement shall be dependent upon, no, it shall depend upon.
Yes,
shall be subject to.
Yes.
It shall be subject to.
Yes, sir.
Actually. This,
Translation
this-
is-
yeah, shall be subject to.
In Assamese version, অৱশ্যে বন্দোবস্তি মহামান্য আদালতে উচ্চ ন্যায়ালয়ৰ গোচৰনামন স্বয়ংচ চূড়ান্ত হুকুমৰ ওপৰত নিৰ্ভৰশীল হ'ব। Dependent, my lord. Final outcome of the order, my lord. Now he can submit, my lord.
Yes.
That Miller. Clause 10 of the NIT Miller was challenged.
Huh?
Clause 10 of the NIT was challenged by some other petitioner Miller who take part in the tender process. That is Miller serial number 21 and 28.
Serial number 2, in which case?
Miller, the earlier Miller, the WC number 3325, wherein the Miller interim order was passed
3325.
that is page 36 Miller.
Already annexed with the writ.
Okay, huh.
Miller. And that case, clause 10 was stayed by the Honorable Court. Miller.
But that was withdrawn.
Withdrawn subsequently on 23rd.
Right.
23rd.
So anyway, that okay,
Yes.
I just want the facts. So it was withdrawn. So even the interim order was vacated.
Vacated. In that case, Miller, I was the party, respondent number 7. I strongly objected. And this Honorable Court was pleased to Miller, allow me
The resolution number 7 and so on, so is applicable to raise their grievance, if any, by filing appropriate application. Order dated
Out here, your respondent number
7
7.
in WC number 3325. Since the resolution was withdrawn,
Just a minute. So this IA 290223 was where you made a challenge. Huh?
I have.
IA
I have filed by some-
290223,
I have filed by some other person.
not by you.
No, I was implemented as resolution number 7. I was filed by some other petition.
But what was the IA about?
I was for implementation.
Okay.
That I was implement. I was implemented earlier.
What was, okay. And what is the grievance? What is your grievance in WPC 6325 of 2023?
It was challenged the close 10 of the NIT. And this honorable court was pleased to state that close 10 of the NIT.
But what can your grievance be? Did you file any affidavit?
No, because before filing that affidavit, that requisition has been.
So you could not have any grievance. So there is no grievance recorded.
Therefore, my lord, it was done on 23/1/2024, and I filed this present requisition on 24/1. Since my lord, the challenge was withdrawn, so immediately thereafter, I filed this requisition, challenging the close state. It is my case. And
Okay.
then my friend relies upon the read appeal number 395. In that appeal, lordship may kindly see the paragraph.
No, wait. Huh? See what? I want to see the judgments. The judgment in this WPC 27 of 22. What is the judge held? What is the courted bench held?
It is close 10 is upheld by the bench.
In this para?
Last paragraph, paragraph 28 million, page 21.
No, in this 27, WPC 27, Rafiqul Islam.
Oh, sorry. People Islam they prayed for not to invoke close 10 of the NIT.
And what did the court hold?
Court hold that close 10 is illegal, that cannot be
Cannot be invoked.
yes,
Where does it say that?
yes, and it is the judgment at place which similar to the 9th.
Let us see, where does it say that?
That judgment I have no.
You don't have it.
That judgment case issue was different, my lord.
Anyway,
That
did the
doesn't-
court allow
Yes.
clause 10 to be applied?
No, my lord.
Why?
In that case, clause 10 was not challenged.
Okay, clause
That
10.
was a different issue. Just one.
Then
comment
why
was-
have you given me the judgment? Who has given me the judgment? Rafiqul Islam, 2 to 27
that
of
was
2022.
So I have given the judgment of 6902.
Okay, you give me six, we'll take up your cases. 6902.
6902.
Okay, out here, what
Yes,
is that? Say? What is the finding?
Lordship may one last bit. Yes, please. First, paragraph 21 20 million.
No?
2021.
So what is the court held here? What is the court held? Where is the operative question?
24, paragraph 24.
Yeah, what does it say? Where is the,
It is about having regard to the point the aspect of the highest bid of the value offered by the petitioner whose bid was compliant to the terms and conditions of the tender notice at the time of submission of bid is considered for the decision of the General Standing Committee of the Jilla Parishad to accept the bid of the resolution number 8 whose bid it is violation of Article 14.
Huh? well, which is in violation of Article 14?
Source 10 of the 90 million. Because my lord, that the facts it is my lord, page my lord 6, paragraph 6.1. By referring to
It does not say in black and white.
my lord, their case was my lord, page my lord, 6, paragraph 6.1. It has just been the case of the petitioner. By referring to clause 10 of the NIT, he has contended that the petitioner being the highest bidder was entitled to be given an opportunity to submit the requisite documents in state of tendering authority had found to be but petitioner deposits some documents in the period of 3 years time. As the clause 10 has incorporated the provision of officer of the unrest money in the event of default to submit the documents to be asked for within the period of 3 the same was required to be floated by the tendering authority. But in the case in hand, the tendering authority did not adhere to the said clause. It is his condition that the tendering authority has to abide by the terms and conditions of the tender notice and it could not have deviated from the same. But it was denied by the
What has he basically said that it cannot be allowed?
yes, madam.
Where does he say that?
Paragraph 21 and the paragraph
Where? Please read.
Madam,
Don't just say 21 or where.
page 16. From the above, it is certain that if clause 10 of the tender notice is made applicable, then the same would for the benefit of the bidders whose bids were invalid at the time of their submission, and the same would be to the principals to those bidders, prejudice to the bidders whose bids were compliant to the terms and conditions of the tender notice at the time of their submission. The issue of acceptance or rejection of a bid of a bidder is to be examined not only from the point of view of both the tendering authority and such a bidder, but also from the point of view of all participant bidders. The said situation is clearly opposed to the principle of equality enshrined in Article 14 of the Constitution of India. The same would clearly be discriminatory in as much as it is as it would result in an anomalous situation where unequals would be treated equally, giving them an unjust benefit over a bidder who is otherwise the highest valid bidder in terms of provision of Assam Panchayat Act 1994 Rule 47 of the rules of 2002.
So 21 says that. So this is okay. Now that is that. I think this is your judgment.
Yes, ma'am.
Then
so, since clause 10 of the NIT was stayed by the another coordinate bench after discussion of the all the earlier cases, then settlement was made to me as a valid high bid. And subsequently the requisition was withdrawn where the interim order was passed. It was withdrawn on 23/1/2024. Allow me to raise grievance.
Yes, a minute. Enough. Any other judgments?
Then only my Lordship Miller, that is my friend which is been relied, that is W number 395.
395.
Miller.
I don't have 395.
Yes, Miller, 390.
Huh?
Shivaram Daka, my friend relied. Read appeal number 395.
Writ appeal.
Yes, my lord.
Yes. What about it?
In that appeal, Lordship may kindly, my lord, see the paragraph 10 and my lord, 10,
Correct.
sorry, 4 and 7 and 8. My lord. Case 4. Paragraph 7, pursuant to the NIP, the writ petitioner submitted bids in respect of 2 markets, so and so, so and so, so and so. It is an admitted fact that petitioner was placed at 13 positions in terms of the bid price offered in the respect of the said market. The learned single judge has declined to examine the issue raised by the present applicant petitioner for the reason that even if such issue raised are answered in favor of the petitioner, the same is not going to have any effect whatsoever to the petitioner. But in the present case, my lord,
No, that is a different issue now. The facts are slightly different.
yes, my lord. But in my case, my lord, since my lord clause 10 was stayed and benefit was given to me, subsequently the writ petition was, my lord, withdrawn. So immediately thereafter I filed the, my lord, writ petition challenging the clause 10. Lordship now, my lord, examine whether clause 10 is, my lord, valid or invalid, my lord, and there are 2 coherent, my lord, bench judgment for the petition. So my submitted lordship, either your lordship may, my lord, decide or it may be referred to the, my lord,
So let me decide.
yes.
May I submit, my lord? Lordship may kindly come to again the repetition 6902 of 2021, my lord. When the
Yes.
clause was discussed. This case was, issue of this case was different, my lord. Here, my lord, petitioner in paragraph, my lord, 6.1, my lord, if lordship will see page
Yes.
6,
Yeah.
page 6. Here, case in this case, my lord, the petitioner was seeking relief of clause 10,
Correct.
which we have denied for petitioner because of some reasons. But this is not challenging the clause 10, my lord. In this case, no one challenged the clause 10.
No one challenged the clause
In
10.
fact, my lord,
Huh.
clause 10 was not declared unconstitutional or set aside. Just those who were not ratio of this case, my lord. Those are running comments, my lord. But lordship may kindly now take
But then the court has held
yes, my lord.
that it is in violation of
Yes.
21.
That was held. Thereafter, my lord, the numbers of bidders specifically challenged clause 10. My lord. That is yes, my lord. 437722 I've submitted on the last day, my lord.
Yes.
Yes. Lordship may first kindly come to page number 11, paragraph 5. This is the issue of this case, my lord.
Page number 11.
Page 11, paragraph 5. This is the issue of this particular cases, series of cases, my lord. As indicated above, there are 5 writ petitioners in which a common question has been raised challenging the validity of the impugn clause. The first writ petition, namely so and so, and the impugn clause is clause 10, my lord.
Yes.
Now, lordship may kindly come to page number 20 is the relevant, my lord. Paragraph 27. This is the finding of the court after discussing the numbers of Supreme Court decisions, my lord.
Yes.
My lord, page 20, my lord, paragraph 27. The present adjudication is also to be done by taking into consideration the law laid down by the Honorable Court in the case of Michigan Rubber so Supra, in which it has been laid down that in matters of formulating conditions of tender, great latitude is to be considered to the state authority, and such latitude is not to be interfered with unless it has been inserted with a malicious intention or to favor
Okay,
a
so
particular
this
party.
is in contradiction to the other judgment.
Yes, my lord. But in these cases, clause 10 was specifically challenged, and the earlier, my lord, that was not a ratio of the
Was just an observation.
yes, observation, running comment, my lord. And thereafter, against this judgment, my lord, that writ appeal was filed, my lord. I have given 390, my lord. That writ appeal was filed after this case, my lord, challenging clause 10. And that was dismissed because of locus of the petitioner, my lord. In the present case also, my lord, petition was initially settled with the market, my lord.
because
okay,
of
that, that much I know. Now, what is this 27 Rafiqul Islam? What is this?
Common.
that is a different.
Lordship, that is, common judgment also. Lordship, five petition was filed along with that lordship, 6902 of the
Oh,
2021.
no, this is only one repetition. WPC 27 of 22.
That is also judgment passed on 17/5/2022.
That is on 75/22, yes.
Same.
Common.
But because five petitions was filed, Lordship, and on same date, Lordship, Honorable Court has heard the matter and passed separate judgment.
Okay.
Same of the.
So same as, so out here also,
Yes. Paragraph 20, 21, 20.
okay, so this is of same thing. So, okay. Okay, now I get it.
Yes. So my.
So
subject is that, my
basically,
lord,
so
we
there,
don't have any local.
so there are three aspects,
Right.
basically. One is whether we should go into the correctness of clause 10,
Yes.
the legality of clause 10. Number two is whether the issue of clause 10 would come into the picture, would have to be decided when he has already submitted his tender
Yes.
on the basis of the clauses that were there.
Yes.
Without, wherein the clause 10 was still applicable.
Yes. That is my point.
Still applicable. However, the only thing is that at the time of selection, time of consideration of the bids, that time the stay on clause 10 was already, was taken into consideration. Naturally, otherwise the highest bidders would have been appointed,
Yes, and the settlement was subject to outcome. of
subject
that.
to outcome. And unluckily for him, those two persons had successfully challenged his selection. Now the selection to be made now is whether clause 10 should be made applicable or not.
Yes,
That is the only issue.
yes, because the prayer of the repetition is only challenging clause 10.
So we can send it to the division bench also for deciding the
Lordship,
issue.
those division bench matters become infractions, my lord. Because those were filed, my lord, because that at that time stay was there.
Ah.
After withdrawing that case, my lord, those cases also become infractions.
But they are still pending.
Pending, my lord, but on the tomorrow, I think it will come.
Tomorrow.
But it is unnecessary, my lord, because I'll submit that infractions, my lord.
No, but then the thing is that the judgment that this court will pass now we can also have a bearing before the DB.
Yes.
Issues are very different, my lord. In this case, my lord,
I think it can have a slight bearing.
lordship can wait for a few days, my lord, otherwise, because issues are different, my lord.
We can wait for the after tomorrow.
Yes, my lord, that can be done, my lord, but otherwise, the different issues, my lord.
Huh?
Yes, after one week.
No, you're having it tomorrow, correct?
Yes,
That
yes,
the
it's fixed,
DB.
But my senior is some,
Huh?
may not be come tomorrow, madam.
Why?
Because my senior, the case is leading by Mr. Bishi Das, madam. He is
Who is your senior?
Mr. Bishi Das, William Sankar Das.
That is not a valid
No, no.
ground for.
No, madam. So,
General
madam, I am paying for after 1 week, madam. This matter. The matter may not be taken.
Now department is running, my lord, but
Yes.
the
I am-
huge
I am
difference is
Just
there
a
my lord,
minute.
for revenue. Revenue is.
Please know when to stop. You start irritating otherwise. We have given you enough time to speak. When he starts to speak, you start interjecting. There are certain, you should restrain yourself.
Otherwise,
You
public-
should quit while the going is good, while you're ahead.
Otherwise, public interest is involved, my lord. We are losing huge revenue, my lord.
No, I'm not on that. I'm on the issue of whether this, because it's a piquant situation. It's not a very normal situation. The thing is that actually at the time of the submission of the tender, the stay was already there.
But yes, my lord. On 12th, my lord, he submitted, my lord. Thereafter only notice was there, my lord.
No, but
But he was not party in that case.
he was a party, he was respondent number 7.
No, my lord. He later implemented himself.
Oh,
Not
later.
implemented himself.
Okay.
Yes, my lord.
When did
He
he?
implemented later on, my lord. When he was
Oh,
beneficiary, he was
okay,
having the fruit, my lord.
okay,
He implemented
okay.
himself. Not from
Okay,
himself.
okay.
Yes.
Uh, after he was selected.
Yes, my lord. He was a beneficiary of stay order, my lord. That is why he implemented himself and objected for withdrawal, my lord. In the whole state, my lord, clause 10 is that it is valid and running, my lord. The markets. Only this Anchalik Panchayat.
Data. Yesterday we have passed some order. Yesterday or day before. Regarding highest bidder, clause 10, they should be given the bid. I think we'll take out that. Okay, we'll list it day after tomorrow.
Fine.
That's all, okay.
Fine.
On the the parties list the matter day after tomorrow. Okay. But this no this I will dispose this separately. No, let be here. Yes. So day after tomorrow we'll dispose everything. I'm just waiting for tomorrow.
My lord.
If anything
They are
happens.
already indicating they will take time.
Oh, they will take time. You're taking time. You're taking time tomorrow.
It is not sure.
If you're taking time tomorrow, then I'll reserve it. I'll pass the judgment by tomorrow. They have to. Just say, list the matter day after tomorrow as parted.
Highly obliged, my lord. Highly obliged.
Just put the envelope on that file I don't need. File you can send, only that I got.
But I have no communication with my client management.
Item?
Well, 10. So my matter may pass for 2 weeks.
Not if the matter is already decided, Lordship. By the CPFs of petition, Lordship. The similar matter. Some of the petitioner went to the division bench, no stay was also there. Actually, they were selected without tender.
Without tender, no?
Without tender, without nothing.
Huh?
Have to take instruction from
And
them.
we have
What is
settled it, we have settled it to the other parties, through tender, Lordship, after that. No stay was also there in this case. Lordship can dispose it of, Lordship.
Where is the relevant portion of the judgment? When the initial settlement is probably
55, the law in the field crystal case has
page,
55, Lordship.
paragraph.
The law in this field case has been extended. The case of the FDC could not have invented a new concept of PB, but therefore attempt to settle in question to the exclusion of other eligible bidders. In fact, such settlements would be wholly in gross violation of Article 14 of the Constitution of India. Actually, Lordship, there was a full bench judgment also not to settle the fishery without tender. So during that process, the officers we have initiated action also against those officers, the MD. We have filed complaint, FIR in the vigilance and suspended all those officers also. After this, Lordship, 22. Okay. 2192, 2022. Twenty-eight, 29, 21, 9, 21, 9.
But where does it say that out here the issue is with regard to no tender was issued?
Okay.
Out here tenders were issued.
No, no, in this case, Lordship, in this, actually somehow it got mixed actually. It was supposed to be tagged with this case, Lordship. So actually, all these cases, there was a judicial order to take all these matters together, Lordship. So it somehow mixed up. Mixed up. Lordship. So parties is there, parties also not interested, Lordship. One
Right.
time like any.
Third, Mr.
P. Sharma.
R.S. Chauhan.
R.S. Chauhan, learned counsel for the petitioner. And Mr.
P. Sharma,
P. Sharma,
pending consider.
standing counsel AFDC. Anybody else?
Point number 6 I appear, madam. And
Mr.
D Gulita.
D. Karita appears for point number 6.
Came here, no? Yeah.
Huh?
You are the respect.
That's right. Then this last order, second paragraph, huh? Mr. Chauhan. learned counsel. Then next para. That will be order dated 4/2/2022, huh? But the second para you take. To stop. The prayer of the petitioners, prayer of the petitioners is to the following effect, 1, 2, 3, huh? To stop. This court, by order dated 4/2/2022, has declined to consider prayer number 2 and 3 of the petitioner made in the writ petition. Full stop. Thus, the only prayer that has to be considered is with regard to whether a direction should be issued to the respondent number 2 to allow the petitioners to run the Warizan Dang Kenduguri Mean Mahal till the end of the peak session. Full stop. Next para. The Mr. P. Sharma, learned counsel for the AFDC, submits that the decision to allow the petitioners to manage the fishery had been revisited as the order dated 3/5/2021 you take para 5, huh? Para 5 of the same order. I'll just give the from here to here. From here to here, okay? Full stop. I have, full stop. He also submits that a bunch of similar matters, the leading case being WPC 2192/2022, have been dismissed by this court by order dated 21/9/22. Full stop. As such, the present case should also be dismissed. Full stop. I have heard the learned counsel for the party. Full stop. As can be seen from the submissions made by the counsel for the parties, comma, the petitioner had been settled with the fishery in question without any tender process having taken place. Full stop. In the bunch of cases, the lead case being WPC 2192/2022, comma, this court, by judgment and order dated, no, a coordinate bench of this court, a coordinate bench of this court by this judgment and order dated 21/9/2022 had dismissed the prayer of the petitioners therein to continue with the settlement of the fisheries, comma, fisheries on the ground that the initial settlements done by the AFDC was not preceded by any procedure recognized by law. First stop. As such, no, first stop. In the present case also, the initial settlement of the fishery with the petitioner having been done without any tender process, comma, the petitioner can have no right to claim settlement of the fishery beyond the period he has been looking after the fishery. First stop. In view of the fact that this is a covered case and as the settlement of the fishery with the petitioner was in violation of Article 14 of the Constitution of India, comma, this court does not find any ground to allow the writ petition. The writ petition is accordingly dismissed.
Please.
Interesting. Yes, out here, what is to be done?
But
You have to give this meeting minutes of 11/10/2022.
lots,
That is required.
lots. Meeting minutes I have, but the further instruction, I have to, I need some time to get.
Okay.
further instruction.
You have got this.
Minutes is there.
You put this in the affidavit.
I'll.
Okay. You have got this.
No, Lordship.
So physical inspection has to be done in terms of this. Okay, right.
In fact, they have possibly done, they have taken some steps. I'll get the up-to-date position.
Okay, right. Mr. Deenat, learned senior government advocate, Assam, submits that he will get the up-to-date status with regard to the meeting minutes dated 11/10/2022. Which was held in the office of the integrated district office. It was held in the office of the additional deputy commissioner Kamrup. List the matter. When?
Give us 2 weeks time.
List the matter after 2 weeks. Miss MD Bora appears for the transport department.
Date to different. 20. Okay.
14 to 18.
But that copy I'll take it.
I think it.
Lots. Okay.
May it please your lordship.
Well, these matters are listed in terms of the order dated 2/2/2024.
Yes,
Well, affidavit has been filed by the concerned respondent
yes.
admitting the amount only, my lord, for instruction whether the fund has been released or not to the extent. This one. Oh, my lord.
Then fund won't be there.
That's what my friend has said. So your lordship,
It is
give
under
some
process,
time, we'll wait for 45 days. Normally, your lordship gives us time. Okay, yes. Your lordship gives some reasonable time. Within that time frame, they will clear the.
We'll close the writ petition. Where is the admission?
Admission, your lordship will find in the affidavit filed by the respondent number 6. Paragraph number 6, 5, sorry.
No, but where is the admission of the amount?
Yes, sir, but it's there. Work completion certificate, they have annexed a paragraph number as annexure A and B.
Yes. Where?
Well, your lordship will find that this is the completion certificate issued and the inquiry was conducted by the deputy commissioner.
Oh,
Prior to that, your lordship will look into the
Yes.
paragraph number 6. Your lordship got it?
But where is the admission of the amount?
This is the entire amount for the entire work that was sanctioned, madam. That your lordship will find at page what in my affidavit running page is 40, the last annexure of page of the respondent number 6.
No, where is the admission of the amount? Admission of the work is there. I'm not on that. You have done the contractual work, that is all right, but where is the admission of the amount?
Your lordship will find that this last annexure at page, my running page is 40.
Yes, I've got it.
Yes, your lordship will find that this is the work which the report of the completion of the SDRF works under Nalbari. The entire scheme.
How much is to be paid?
For the amount sanction is 11500L. So far, my lord, the different petitions are concerned. But
I'm not on that. You
Well,
know
I have-
exactly what I want, but
Yes,
it's not there.
The total work is 15 lakhs and 76,000. All the 4 petitions I have given the amount, my lord. It will be easier for your lordship.
No, I want the admission on the part of the government.
But this is the admission, my lord.
Where?
The work has been
Look,
completed.
because you are claiming out here 15 lakhs 767. Correct?
Yes, madam.
Now, where is the 15 lakhs?
No, this is for the entire amount.
entire
sanctioned for-
work is the difference. Yes, how much is the amount payable by you?
Your lordship, they have it.
Huh?
No,
Then why
no.
haven't you verified?
Now, page 21, your lordship will find in of the read petition, my lord, the amount. The approximate value of the work. Page
Again, you're going back to the same issue,
page
approximate
20,
value.
Yes,
I am not on the approximate value, Mr. Council. I am on the amount that you are to receive.
well, they are not disputing this amount, but
You're not disputing.
not disputing. That's in the last order also it is reflected. If it is disputed, then it is a different thing. They have said that I have completed the entire work, everything and all. That's why I am entitled to this amount.
Let me see where it. Y'all are also beating around the bush only.
they will consider, my lord, since there is no dispute in regard to the amount, my lord. So they will, and in similar type of, my lord, from the same work, my lord, there is a similar order which I have annexed at page 31. Same work order, my lord. Paragraph number 3, my lord. Paragraph number 4 is the relevant paragraph at page 33. I think this will suffice the purpose, my lord. Paragraph number 4 at page 33 of the writ petition. In view of the above submission of the learned counsel for the parties, this writ petition is disposed of at the admission stage itself with a direction to the Chief Engineer, Water Resource Department, Assam, to examine the claim of the petitioner within a period of 45 days from the receipt of a certificate. And then if the claim is admitted, the respondent authorities will process the claim of the petitioner in accordance with law in the light of the right. I think this will suffice the purpose, but instead of,
No. There is no admission.
here also, but the direction is to
This is
examine
a,
the claim.
this is a writ petition, Mr. Council. It's not so simple.
But they have not disputed this amount in their affidavit, man.
They have denied.
No.
Unless it is, they have said that, they have said that, the deponent does not admit anything which is contrary to or inconsistent with the record of the
My
case.
lord,
So
that
they
is,
have not admitted
my
basically.
lord, that's a general statement given at the.
Yes, why are you just beating around the bush? We'll call this person. Huh?
Executing authority, the water, they may be the proper person.
Yes. Affidavit of? So why haven't you stated it? Then why aren't you verified? What's stopping you from verifying?
That's the direction given at paragraph number 4 at page 33. It's not a specific direction. You will have seen that paragraph 4. In view of the above submission.
Right.
this
No,
writ petition is disposed of
Let them make a specific thing.
to
William.
examine the claim of the petitioner within a period of 45 days from the receipt of a certified copy of, and if the claim is admitted, the respondent. This I think will suffice. Let them do it. They will verify it.
No, that verification thing.
Because the deputy commissioner, who is the executing authority, has found that I have executed the work. Only due to lack of fund, only it is not being paid.
No, the
And you also will see the paragraph number 5 of the respondent number 6 also of the affidavit.
no, it says here. That the letter says.
Physically verified the SGI, accordingly the completion report of the
Right,
SGI scheme
Mr.
was.
B.D. Kumar, learned senior counsel for the petitioner. On a perusal of the pleadings, comma, it is seen that the petitioner has made a claim for unpaid contractual dues amounting to
I have given in all the cases, it's a different, that's why I made it.
amounting to
15 lakhs.
rupees
In the
15,
first case,
comma 00, comma 767 and rupees 6, comma 306.
yes, ma'am.
Full stop. The respondents, know who appears? Miss name. R. Deka appears for phone number 1, 2, 3, and 4. Then who else?
And I am for 5 and 6.
Name
G. Bokulia.
5 and 6. And anybody else?
I am for number 7.
Name.
Yes, doctor.
That's data for number 7. Anybody else? A. Chaliha for? That's one number 8. Full stop. The letter, the respondents councils have submitted a letter dated 5/2/2000, no, 5/2/2024. Issued to Mr. S. Datta, Standing Council, Revenue and DM Department. Which is to the effect that the matter is under examination and necessary instructions will be provided shortly. Ustad. Who is to verify this amount? Miss R.M. Dekha.
No, my lord, the executive authority, the deputy commissioner has already verified who is the executive agency.
Where is the verification of the amount? Amount is not there.
Work was verified,
Work may be verified, Mr. Council.
yeah,
The amount-
contractor will do the work, my lord. They don't do their work, my lord. I can't be held responsible for it. Well,
I know that.
yes.
That's why you have come here. And we also cannot pass an order. Only on, you have to go to the civil court, in fact. We are asking, that's why we want the admitted amount so that we can pass an order in your favor. Otherwise, you go to civil court. Okay, Mr. S. Datta, and then it's the Council for the Revenue and DM Department shall provide specific instructions by the next date by way of an affidavit as to whether the contractual dues of the petitioner amounts to rupees 15,00,767 and rupees 6,306. Then it's all the cases you write that the exact
Only amount
number.
will be different. I have given a chart.
only the numbers will be different.
Amount, that's why I given
So
a.
these are the charts. So specifically we want
Well, your lordship can also direct the finance department to file a affidavit in regard to the funds, madam.
no, they'll never have money. That will once they give the admitted amount, then we'll direct. That will not happen.
The problem is that the petitioner has not served copy to our lordship till today.
We'll serve it, just sorry. If you had pointed it out that day, I would have. Uploaded.
You give it to them.
Uploaded.
Okay.
List the matter, okay. And the affidavit should be filed within 2 weeks, 3 weeks, 3 weeks. List the matter or give a date.
On 6 March, I will not be available. May I pay it on, madam, on 11th of March?
11 months. Yes.
May I please, your lordship? Your lordship kindly peruse last order dated 8/1/2024, my lord, by which the government advocate was asked to obtain certain instruction. Because, my lord, the one additional deputy commissioner has admitted the amount payable to the.
How much has he admitted?
Annexure 2, page 19, my lord, the total amount is 1,80,055 rupees. Annexure 2, page 19, my lord. Because the bill submitted by the petitioner that some modification was done by the.
Where is the admission? Where is the admission?
My lord, Annexure 2 is the admission because this is the.
Annexure 2 is a letter written by whom?
By the petitioner, my lord. And in page 21, your lordship will find the.
It is a letter written by the petitioner. It is not an admission by the
My lord,
correspondent.
Those amount has been modified by the deputy commissioner and he has put his signature at page 21, my lord. Page 21, my lord.
Let us see what is, page 21.
Yes, my lord. Because
No,
the amount has been modified by hand by
Sorry.
the concerned the additional deputy commissioner, my lord. And that's why, my lord, on earlier occasion, my lord, this honorable court has been pleased to obtain instruction regarding that particular point, my lord, from the concerned additional deputy commissioner, my lord. On the bill of the petitioner, my.
Yes.
My lord, regarding this annexure, last order, I don't have any instruction till now, but however, we have received the parallelized comment, my lord, where petitioner was asked several times to produce the vouchers, case memos, etc. And without any formal order, it was.
You file an affidavit. You file.
We have already filed, my lord.
Oh, you filed.
We have already filed. But this letter It is petitioner's letter, my lord. Just,
I know,
No.
that cannot be accepted.
my lord. Otherwise, no,
But
we
the
have filed already affidavit, my lord.
signature of the additional deputy commissioner, that cannot be, it is, my lord, during the.
Then you go to civil court and you
It
prove the
is-
document.
No, my lord, it is during the election time, my lord. That is the normal procedure, because on the spot, my lord, something is ordered and because, my lord, at annexer one, my lord, the petitioner has been shortlisted for supplying the articles, my lord. Annexer one, page 17, my lord. The petitioner along with 5 others, my lord, they have been shortlisted for supplying this type of articles, my lord, during the time of election, my lord.
The petitioner was requested to supply orders and copies of challan, which are required for payment. But the writ petitioner could not submit any document.
Yes, my lord, that cannot be submitted because page 17, if your lordship peruses, my lord, six persons were shortlisted for supplying article, because on the spot, if your lordship sees the items.
Mr. Counsel, this is not, then you go for, you adduce evidence before the trial court. We cannot do it on the basis of your submission.
On basis of the last order dated 8/1/2024, my lord, from the specific instruction has been sought for. That instruction let them obtain, my lord.
No, he's taking the view.
No, my lord. He is saying that, my lord, to submit the work order. There is no work order, because if your lordship peruses the items, my lord, your lordship kindly come to page 19, my lord. Page 19, my lord, because on the spot, while conducting the election work, my lord, these items are ordered. Kalakan, kasuri, milk tea, half liter drinking water.
Correct. How will he produce?
Yes, my lord.
How will you produce this kachori and all?
Yes, my lord, that is the thing.
You have one rasgulla, you don't give supply order for one rasgulla.
Yes, my lord. And it has been admitted by the concerned additional deputy commissioner at that time, my lord.
My lord, without any, it's government process, my lord, to clear the bills, my lord.
Some amount has been paid to the petitioner, but these remain unpaid, my lord.
But what to do, Mr. Counsel?
That is on.
Now you see, the problem is, it is your word against theirs. Whether you supplied half liter drinking water, how can we say that, yes, you supplied half liter drinking water?
And because of that, because it has been countersigned by the deputy, concerned additional deputy commissioner by modifying the rates and other things with his own handwriting, my lord. Your lordship may see the.
That is why, please, you go to the civil court and prove it.
First, my lord, let him obtain instruction from the additional deputy commissioner, concerned additional.
Okay, right. Mr. Bopalai, learned counsel for the respondent, submit that he has not received instructions from the concerned additional deputy commissioner.
In terms of order dated.
In terms of the order dated 8/1/2024, he is granted another 4 weeks time to obtain instruction. This is the matter to come.
Can it be, my lord, 2 weeks, my lord?
No,
My
no,
lord,
there are too many, all the cases are getting crammed up.
Next
there.
election is coming, my lord. It was of the last election.
May please lordship, kindly pass over the matter for time being, lordship. My senior is on next.
Or any other day, my lord.
No.
22.
No one appears.
Item 22.
22, yes.
Well, this is an application for appointment of arbiter.
Where's the other side?
Well,
This-
other
okay,
side,
there.
since long they have not filed any affidavit. Repeatedly, they are taking time. As per Supreme Court directive, the matter. has-
Correct. No, we'll appoint. They don't want to come.
Last of.
Where is the arbitration clause?
My lord. The arbitration clause, my lord, that is at page 129, my lord. Clause number 64, demand for arbitration. So according to clause 64(1), firstly, we have to write a letter to them to settle the matter amicably. And accordingly, we have complied with that requirement. Clause 64(1), then clause 64(1) Roman 2. It is demand for arbitration.
Where is your demand
My lord, that
in
is,
writing?
my lord, that is, my lord, annexure number,
Page.
that's page number 134. Page number 134. Annexure 11. Here in second page,
Yes.
in second page, 135, para 6.
Yes.
That reading all our arguments, we have sent you letter dated 22/12/22 requesting you to resolve the dispute and to pay the amount as claimed in the said letter within 120 days of receipt of the said letter in terms of clause number 60 of GC. But nothing had been done on your part to resolve the dispute amicably and lawfully and to make payment of it. Instead, you have sent us letter number such and such to justify your actions as against such letter. We have replied, since you have failed to resolve the dispute and did not pay our lawful dues till expiry of 120 days. 120 days notice we have to issue them according to clause number 63(1). So that has expired. As such, the dispute is required to be referred to arbitration, and hence we request you to appointment of neutral and unbiased arbitrator to resolve the dispute and educate upon the matter.
How much is the claim?
Look, claim is also very small amount. It is two amounts are there. One is 17,14,302 and another is 9,77,021. The two heads, my lord.
So this will go, this will go to a panel of arbitrators.
My lord.
Three arbitrators.
My lord, it will be
A sole arbitrator.
sole arbitrator, my lord. Sole arbitrator.
Only thing is that since they said that
They had actually after receipt of letter.
they want that it should be an officer of the railway, which
Officer of
cannot
the
be,
railway.
which cannot be,
Which cannot,
because of that Eastman Perkins statement.
officer of the railway.
Yes, who's appearing? No one's appearing. He was here, Mr. Gupta was here.
Actually, he has not been, perhaps he has not been allotted the case. Case had been allotted to someone else.
Hey, Miss A. Gayan here, somewhere. This
Last occasion, they said that they have received the instructions, so by next date, they will file the.
correct. Right.
And she is appearing, she is coming now.
What have I said? Heard Mr.
Yes, sir, ma'am.
S. Sharma, learned counsel for the petitioner. Also heard Miss A. Gayan, learned CGC appearing for the Union of India. This is an application under section 11.
I have received it today, my lord. I'm going to file affidavit in opposition.
When?
My lord, within 2 days, my lord. This week, my lord.
You have received the
Taking
affidavit.
inspection and also sending for
So-
fitting, sir.
Yeah, you have already sent for it. It's
Yes,
come
ma'am.
back.
Yes,
It has
ma'am.
come back.
Yes, my lord.
And what is your stand going to be?
Ma'am, kindly take on Monday, my lord. In the meantime, I will file affidavit Monday or Wednesday, my lord.
Okay, wait, then right. Whatever I said. And this is an application under section 11 of the Arbitration and Conciliation Act, 1996. Herein after referred to as the 1996 Act. Whereby the petitioner seeks appointment of an arbitrator on the ground that disputes and differences have arisen between the parties out of contract agreement number CE/MLG/TWR/TSK-01 of 2015 dated 19/10/2015, executed for, no, not executed, for execution of contract work VIZ full stop, bracket, not bracket, invert commas, welding of 52/60 kg, bracket 90/72 UTS, bracket close, new/SH rail joints in situ by using the contractor's own mobile flash butt welding sensor in the order dated 29/9/23. Second paragraph. Next paragraph. The petitioner's counsel submit that the arbitration clause is provided in clause 64 of the, what is this? Of the
GCC.
Huh?
The
Of
general
the-
condition of contract.
of the general conditions of contract, bracket GCC. Full stop. He submits that in terms of the general conditions of contract, the petitioner has invoked the arbitration clause by submitting a letter dated 22/5/23 to which respondents?
To the respondents.
To the respondents number 1 and 2.
Yes, sir.
Due to non-payment of their contractual dues. That's all, no? Non-payment of contractual dues.
Yes, sir.
Yes, sir. The petitioner's counsel submitted that the claim of the petitioner amounts to rupees, how much?
26,91,323.
26/91,
323.
323. Now, the problem is, full stop, next paragraph. In terms of clause 64 bracket 3, bracket small a, bracket Roman 1 small. Claims not exceeding rupees 10 lakhs have to be heard by an arbitral tribunal consisting of a lone arbitrator. While in claims exceeding the said rupees 10 lakhs, the arbitral tribunal is to consist of a panel of 3 arbitrators. Now you obtain instructions with regard to whether it should be 3 or 1, because it's going to be costly. As per I'll tell you why. As per your arbitration clause, the arbitrators were supposed to be railway officials, which cannot be done. So you're going to have 3 arbitrators.
I'll take instruction on this, sir.
You may go for one arbitrator, otherwise three arbitrators
No,
will be very
no, please
costly.
obtain it. Full stop,
Very
next
costly.
para, right. Ms. A. Gayan, Leonard CGC submits that affidavit is ready for filing and the same will be filed within 2 days.
The affidavit is coming in 2 days, my lord.
Within 2 days, full stop. He is further directed to obtain instructions with regard to whether they are agreeable to, right to obtain instructions as to whether the matter can be decided by a lone arbitrator. In the event this court directs that the dispute should be decided by way of arbitration. By way of arbitration. So list the matter on
13 or 15, my lord, any day.
13,
1, 3.
13.
30.
First apply.
Yes,
Please, Lordship. This is an application for appointment.
arbitration. Yes, any objection?
My lord, objection is there, my lord, because, my lord, the terms of the contract, my lord, will take the arbitration petition 36.
Huh?
Arbitration petition
36, yes.
36, my lord. My lord will take the arbitration clause at page 8.
Page 48.
My lord, page 48, 50 onwards, my lord.
Yes.
It starts with 48, my lord, and the relevant portion I am referring is page 51. That is 64.7, my lord.
Yes.
My lord, this states, my lord, that the subject to the provisions of the aforesaid Arbitration and Conciliation Act 96 and the rules thereunder, and any statutory modifications thereof shall apply to arbitration proceedings under this clause. The provisions of 64, 63 and 64 to the general conditions of contractors will be applicable only for settlement of claims or disputes between the parties for values less than or equal to 20% of the value of the contract. And when the claims of dispute are value more than 20% of the value of contract, provisions of 63 and 64 and other relevant clauses of the GCC will not be applicable, and arbitration will not be a remedy for settlement of such disputes. So, my lord, in both these cases, my lord, the claim amount is more than 20% of the contract value, my lord. I have received the instructions. My lord, one is the letter dated 4/10/2023, the paragraph 3, my lord. Paragraph 3, my lord, if I may read the second line, on receipt of documents, it was found that the final claim amounting to rupees 3
75%.
is 75.60%. And in the other case, it is, my lord, 36.68% more than the contract value. So, my lord, if the petitioners.
So do you go to civil court?
My lord. And also I rely on the judgment of the Delhi High Court, my lord, wherein I think
Are you going to do it or your senior or what?
Lordship, in this respect, my senior, he will make some submissions on it. Lordship may fix it the day after tomorrow, Lordship.
Where is he?
Lordship, he is out of station, Lordship. Today evening, he will reach, Lordship.
This is the judgment of the Delhi High Court, wherein similar issue came up, my lord, and on the ground of paragraph 12.
Okay, this 410/23 pertains to which case?
My lord, 410 pertains to arbitration 36, my lord.
Okay, right.
And the other one
Right,
pertains to
all right. Mr. What is your name? Mr. A. Ahmed, Leonard Counsel for the petitioner. Says that the matter may be adjourned as the senior is out of station. Mr. H. Gupta, Leonard Counsel for the respondent, submits that in terms of clause 63 and 64, is it?
my lord, it is 64.7.
64.6 and 64. No, where is that? In terms of
Under 64.7, my lord, there are three clauses.
In terms of clause 64.7,
my lord, then dash 10.1.
how can it?
Since there are sub clauses are there.
64.7,
My lord.
how can it be? Then it comes.
No, my lord, within 64.7, there are three
Well,
clauses.
64 and all must be with regard to
64 is regard to arbitration. Starts from page 48, my lord. Demand for arbitration.
that means that in terms of clause 64.7, comma 10.1,
My lord.
10.2 and 10.3 of the GCC. Claims or disputes for a value less than or equal to 20% of the value of the contract can be decided by an arbitrator. First of, however, claims beyond 20% cannot be decided by way of arbitration. First of, he submits that the claim made by the petitioner is 75.6% of the total value of the contract. As such, the matter would have to be decided through a civil court. First of. Then in the other case also same thing, except out here it will be 36.68%. Okay. So list the matter, no, first of, then you, before that you also write, he also submits that, in support of his submission, he also submits that he also submits that the Delhi High Court has upheld the said provision in ARB P 933/2022. MS BCC Mona Lisa JV through Container Corporation of India Limited. It's here in the file. List the matter when?
Tomorrow or day after tomorrow?
It's a small issue. It's a small thing, my lord. Tomorrow is too short. Next week, huh? Monday is too much, I think. Too much.
Lordship, not 15 lordship, because he will be not there, lordship. 15 period, not 16 to 18.
16.
But, according to us, there is no such dispute because the moment he gives us the forest royalty document, amount will be clear to him. That is in our affidavit we have stated.
So forest royalty documents.
My lord,
It is because of him, he has delayed, Malad. That is why. It is because of him, Malad. He has delayed. That is why the.
So it went beyond the time period. No, so yes, forest, yes.
my lord, forest royalty is one point. Apart from that, the date of completion and other issues, bonus and GST bills, etc., are not paid. It is about 1,71 lakhs. So that is why.
Okay, so there is a dispute. That's all.
My lord.
There is a dispute. Where is the affidavit, right?
Look, we filed it today. It is not, it has not come.
Just 15 minutes earlier we have
Yes.
received it.
Oh,
I could file it today.
so can we do it on the basis of your copy?
On this basis of
Day after
copy,
tomorrow, day after tomorrow, can I pick up? I have a copy, but I can give her.
annexes are not available.
Yes, where is your submission? Okay.
Yes. So the final paragraph, kindly see, Malad, para 9. Para
Yes.
9. Completion certificate is not issued, that is his grievance. We said that completion certificate is already issued to the petitioner. The payment of unpaid final bill is to be made only after submission of the undertaking. Undertaking he has not given. As regard the refund of forest royalty, already stated in paragraph also that the document he will produce and we will adjust that.
Yes, why are you not paying this 3% first royalty?
For 3% first royalty, we have already paid.
Already paid?
Paid.
So these are all disputed,
That-
this is,
That is.
so you
another
see,
issue.
there are three things.
No, sir.
According to them,
Look,
there are three
my lord.
things.
Yeah.
One is unpaid final bill. One is the completion certificate is issued,
That is issue.
Not yet received, not yet received.
not
my
yet
lord.
received. Okay,
is issued.
then you give it to them.
And,
Then, okay, next is
and the.
Um,
undertaking.
unpaid final bill is to be made only after submission of the undertaking. So undertaking have you given?
My lord, we have given the undertaking
Undertaking.
lately, but with these conditions that all other disputes will erase. Other than the payment.
Well, then what is the third is the refund of the forest royalty?
Yes, sir.
Uh,
Forest royalty document they have submitted, those documents are before the NIT. Before the NIT was issued at a date. That those documents are prior to that NIT. How can he obtain the forest royalty document before the NIT law? Those documents possibly belong to some other thing.
correct, correct. How can there be a forest royalty prior to the NIT?
So, my lord.
Let
we
us
have-
see your NIT. Let us see your,
exactly, I
let us
have to
see the
check
forest
it.
royalty.
Forest royalty deposited to DFO Baksa district in Kukurada before.
Show me the document,
Yes,
page,
Annexer 4,
page.
Annexer 4, page 24, 21. Without submission of forest royalty, contractor is not allowed to carry the materials
Huh?
at that time.
Without?
Without payment of forest royalty to the forest department, contractor was not allowed to extract the materials.
Correct. So, this is of 9/2/23,
No,
correct?
Yes.
Mine is a letter. Mine is a letter, Lord.
Okay, where is the
But
forest
it is
royalty?
later.
Letter.
Where is the royalty payment slip?
Payment slip. Payment slip is, I have to submit it.
Huh?
I have to furnish it. It is not, I have to furnish with the.
You bring it, you bring it. And what is the undertaking that they have to give? What is the undertaking?
But
That they do not claim anything.
as you got maintenance or
Yes,
something.
my lord.
Uh-huh.
But in contract.
That cannot be done.
It is not there.
No, as
So my client is not applied.
As regard the maintenance and all these things, they have to give an undertaking as per the terms of the contract.
No, you see, undertaking basically what you want is that he will not claim anything. That cannot be given.
That is not as regard the. claim.
Only thing is with regard to this forest royalty,
Gotcha.
the payment slip. You please show.
Obliged.
Okay. All right, Mr. Dinath submits that the affidavit in opposition has been filed today. The petitioner's counsel, Mr. B. Das,
Be there.
submits that he will produce the forest royalty slips on the next date. List the matter when? After 2 weeks. Next.
Obliged.
But I'll take back the affidavit submission. My. not- Okay.
I will submit the counter affidavit on.
Yes, madam.
Counter affidavit on this. Connection.
Item 26.
25.
You want to file a reply.
Okay.
You want to file a reply?
Reply to.
Okay, you file a reply.
Yes.
In the other one, the petition counsel is also given the liberty to file a reply affidavit.
May I please your lordship, I am appearing on behalf of the petitioner in this case. Your lordship. Your
Yes.
lordship, in this case, the
Yes, so any objection?
Your
What?
lordship, we do have our objection, your lordship, because there is one agreement that has been signed between parties, your lordship, and your lordship. In that memorandum of understanding, your lordship, it is clearly mentioned that paragraph page 118, your lordship, paragraph 56.
Yes, your lordship.
Yes.
Arbitration in the event of any dispute arising out of the contract between the parties here to the same shall be referred to the sole arbitration of the state government or any officer appointed by the state government on its behalf. The proceeding held by the arbitration in making award will be in accordance with the provision of Indian Arbitration and Conciliation Act 1996 or any statutory amendments thereof, the award of the arbitrator shall be final and binding on the parties. After studying your lordship, both the memorandum of understanding, they have signed it, your lordship. And in regard to that, your lordship, one writ petition has already filed, your lordship, that has been dismissed, your lordship.
Yes, your lordship, one writ petition
Yeah.
was filed, your lordship.
Filed by you.
Yes, your lordship.
For what?
Your lordship, what had happened in this case, a unilateral cancellation of the agreement was done without
Huh?
giving us the
What?
unilateral
Cancellation
cancellation of memorandum
agreement?
was done, your
By
lordship,
whom?
by the respondent number 2, your lordship,
Who is the respondent number 2?
is the state nodal officer, your lordship. For
Okay,
mission director.
he cancelled the
Yes,
memorandum of
we
agreement.
filed a writ petition, your lordship. To that effect, your lordship, we were given the liberty to invoke the arbitration clause, your lordship. And the limitation was also excluded.
Show me the order.
Yes, your lordship. At page, your lordship, 152, your lordship, the order.
Annexure 16.
Yes, your lordship. And the relevant portion is at page 154, your lordship. May I read?
You are an NGO.
We are an NGO, your lordship.
What is your grievance here?
So lordship, what had happened, we established the centralized kitchen after expression of interest was given in our.
That much we know.
Yes, sir.
We know. Now, what do you want in this writ petition?
Your lordship, actually, we want that the agreement should be restored, your lordship.
How?
And your lordship, because the memorandum of understanding which was executed between the parties, to that effect, we have already established our kitchen, your lordship.
No case.
No, your lordship, to that effect, your lordship.
No, what,
Because
to what
there's
effect?
an arbitration clause.
Mr. Counsel,
Yes, sir.
there was an expression of interest.
Yes, your lordship.
And you were allowed to serve the midday meals to schools.
Yes, your lordship.
For how many years?
3 years, your lordship.
3 years.
Yes, sir.
Has that period expired?
The period has expired. your
Now, what do you want in
That,
this case?
your lordship, they have cancelled our order. After we established the kitchen, your lordship, final inspection was done, your lordship. They unilaterally cancelled that agreement before we could have delivered anything else. So under such circumstances, the arbitration clause is there, your lordship.
Correct.
And the dispute out to have been resolved between the parties. your lordship.
Then?
To that effect, we also wrote a letter to that respondent number 2 to reconsider our.
No, just tell me one thing. The agreement was cancelled.
When it was valid, your lordship.
Agreement was cancelled or not?
Yes, sir.
Now you put that to challenge in a writ petition?
Yes, your lordship.
Writ petition has been dismissed.
Yes, your lordship.
What survives now?
Your lordship, because since there is an arbitration clause, we were.
But you have availed of the writ petition. You have availed of the remedy under 226.
Yes, your lordship, but.
Bypassing that arbitration clause. You have got no right.
That was referred, your lordship, and in page 154, paragraph 9, your lordship.
Yes,
May I read, your lordship?
yes.
However, before parting with the record, the learned senior counsel for the petitioner has referred to clause 56 of the MOU, which contains arbitration clause. The court is inclined to provide.
Wait, 154?
154 page number.
Okay, yes.
And paragraph 9, Your
9,
Lordship.
okay.
However, before parting with the records, as the learned senior counsel for the petitioner has referred to clause 56 of the MOU, which contains arbitration clause,
Okay, shall not be a bar.
shall not be a bar. So that liberty was given to us, Your Lordship. And accordingly, we also issued the notice to the respondent number 2.
So what are you claiming now? Compensation or what? You cannot claim that you should be restored the
Third
position prior to that. That cannot be done.
Your Lordship, I do not have any specific instruction as to what. should
You
be
have got
done.
to make a claim, mister.
Yes, Your Lordship, because
What is-
I'll take. a
What specific instruction? You cannot come with a vague case and
And
ask
that's my-
the High Court for a vague order.
Your Lordship, I'll take a specific instruction from my client, Your Lordship, as far as petitions are done. Your Lordship, maybe please grant 1 week time. to-
How did you file the case in the first place?
No, the arbitration agreement was there, Your Lordship. Accordingly, we first filed a writ petition for setting aside that cancellation order, Your Lordship. And thereafter, since we have evoked the arbitration clause, Your Lordship,
Just a minute. Your case is gone. This court has already held. The period of engagement of the petitioner was for 3 years.
please, Your Lordship.
They expired. Therefore, as the contract is found to be determinable in nature, the petitioner is not found to be entitled to any further specific performance of the contract after lapse and expiry of the contract period covered by the said MOU. So even the arbitrator cannot grant you your wish. At best, the petitioner would perhaps be entitled to approach the civil court for seeking damages
Compensation is to advise.
and or compensation if so advised.
Yes, Your Lordship. Because at the last operative part, Your Lordship, we propose that there is an arbitration.
Okay, you want to go for arbitration, but what are you claiming? What are you going to claim before the arbitrator? Or you'll first go to the arbitrator and say that, let me think about it. What is you have got to come with a definite plan.
Yes, sir.
What do you want to claim? Now, prior to claiming before the arbitrator straight away, you have got to make a claim to the authorities. Now, because you have not allowed me to work for the period of the agreement period, I have incurred so much expenditure in building centralized kitchen, so and so. So compensation or damages of this much amount should be given to me. Now, when that is not considered or is denied, then you can ask for resorting to arbitration. But as of date, you have not even asked them for compensation or damages. Your prayer for continuing the kitchen cannot be allowed anymore because the single bench of this coordinate bench has already rejected your prayer.
I'll come with a specific instruction on the next day, Your Lordship. Can you give me 1 week time, Your Lordship? I'll just,
There is no specific instruction.
because Your
It's
Lordship,
either you withdraw
Nothing, sir.
or I pass an order.
Yes.
There's nothing to what specific instruction? What is your client going to tell you?
Your Lordship, if I approach a civil court, Your Lordship, as of today, Your Lordship, since there is an arbitration clause, that
That
will
is
come
why-
into
that is-
effect, Your Lordship.
That is, you see, prior to going to a civil court also, please listen. Please listen. First of all, you have got no avenue left. Your prayer to continue the kitchen because it was closed beyond prior to you finishing your term, and your prayer for continuing, giving you extra time to continue the work, has already been dismissed by this coordinate bench in this writ petition. So that prayer cannot be is of no use to you. The only prayer you can make, as per a reading of this order, is that you can make a claim for damages or compensation. Now, to make a claim for damages and compensation, first you have to ask them, this is my damages, this is my compensation, please pay me. When they say no, or when they don't consider, then you resort to arbitration or a civil court, not prior to that. You know, it's like two friends suddenly walking, and then one suddenly goes to court and says, he has to give me 100 rupees for something that happened some days back. Right? First tell your friend, hey, you took 100 rupees for buying that packet of cigarettes. Now please pay me the 100 rupees. Give him some notice. Outside you're not doing anything.
In this present arbitration petition, Your Lordship, I have drawn two facts, Your Lordship. The amount of expenses which we have incurred has been annexed in this arbitration.
Have you made a claim that they should pay?
No, Your Lordship, because.
Where is your prayer to them? Where is your
At page-
representation?
At page 156, Your Lordship.
126, yes.
156, Your Lordship.
Yes.
Very nice. Your Lordship, may I please to refer at paragraph 10, Your Lordship, 158. Your Lordship.
Yes.
Evidently and admittedly dispute regarding the claim for loss sustained by our client on account of arbitrary.
How much, Mr. Counsel? How much? How much? How much is the claim? 1 rupee, 50 paisa, 20 lakhs, 50 lakhs, how much?
That is not it.
Huh? Very easy to say, I have made a loss. Okay, you have made a loss. You have not said any amount. Take 1 rupee, go. Then what will you do? You've got to make a claim. No, it's not 1 rupee. My damages is 2 lakhs, 20 lakhs, 30 lakhs. You've got to give a figure.
In the pair portion, Your Lordship, that is on page 22, the only pair portion is appoint arbitrator, panel of arbitrators. There is no claim prayer is there, Your
No,
Lordship.
claim is not required. But they have got to give some representation, some document showing, or some pleadings that they claim something
Out of
from you, that they have made a claim against you. He has not shown what he has claimed against you. His claim to be given extra time to run the kitchen has been dismissed by this court. So that claim is gone. Now the only thing he can claim is damages and compensation, for which you make a separate claim to them by way of a representation. Once that is denied, then you can come under the arbitration clause or the civil court, depending.
I may be allowed to withdraw with the liberty, Your Lordship.
Ah.
With the liberty to file a claim, Your Lordship. Because notice was
Okay,
issued to be
okay,
with
okay. No, right, okay, right. Heard, Mr.
S. Sancheti, Your Lordship.
S.
Sancheti.
Sanjeti, learned counsel for the petitioner, who submits that in view of the order dated
Your Lordship, 26.
26/6/23 passed by this court in WPC 1620/2022, the petitioner may be allowed to withdraw the writ petition, withdraw the arbitration petition, and file the same afresh.
With the liberty.
With the liberty to file the same afresh. Miss,
MS P. Das on behalf of P. Nayak, Your Lordship, for respondent number 2,
you got it?
SSA.
Appears for the respondents. The prayer of the petitioner's counsel is allowed. The arbitration petition is dismissed as withdrawn, come out with liberty as principle.
Highly obliged. Sure.
Deeply obliged.
You got it, Mr. Counsel, you
Yes,
got
yes,
it.
yes.
Yeah.
Highly obliged. Your Lordship.
Okay. Why did we keep it for? We said for the after tomorrow, we said, no?
It is another matter, my lord.
Oh,
Another,
another matter.
Yes, yes.
Oh. What is this?
My lord, the petitioner, my lord, you was
Item?
20.
20 minutes.
Yes.
In this case, my lord, he is seeking for return of the, my lord, earnest money, which was, my lord, deposited at the time of submitting tender. The facts of this case, my lord, the, my lord, Batodara Anshalik Panchayat, my lord, issued a NIT, my lord, 110/5/2021. That is, my lord, page, my lord, 13.
Yes.
Then, my lord, that is close 10 again, my lord. Your lordship has already, my lord, that, my lord. In view of the, my lord, close 10, the, my lord, highest bidder shall be considered if he did not submit, my lord, required documents, and he will allow 3 days time to submit those documents. In this case, my lord, the petitioner was the second highest bidder, and one, my lord, Ramadur Rahman, who was the first highest bidder. Then, my lord, in terms of the, my lord, close 10, my lord,
The highest bidder withdrew his bid or?
yes, my lord. Then, my lord,
Then you were offered settlement.
not offered, my lord. The authority asked me to submit those.
Naturally, that
Yes,
means
that is
the-
okay.
that,
Yes,
that means you were in the reckoning
That, my lord, then I sought for some more time
beyond 3 days.
beyond 3 days, but it was not allowed.
You're
Absolutely.
bound by the terms and conditions of your tender.
That is true.
Then
Only some people lost in Miller. The settlement was made subsequently to some other person. He has completed.
maybe,
But
but it has gone down in sequence.
Then Miller only because Miller the earnest money when can be Miller forfeited.
Okay.
Lost in Miller can be Miller the
Let us see, first of all, let us see the tender document.
Page
The
14.
tender
clause
notice,
10.
page 14.
case 14.
But clause 10 provides that if you cannot submit the required documents,
Yes.
then tender will be rejected and earnest money forfeited. Then
It is there, but I sought some more time.
the tender conditions are there.
That was not considered.
Then what is wrong in not returning you your earnest money? What is wrong?
Miller, and since Miller that close Miller at that Miller the relevant time Miller it was Miller state Miller yes.
Huh?
That is the Miller decision of the Miller earlier.
Whatever may be out here, that is not the case here.
No, Miller.
Then
But my submission people lost in Miller. The earnest money only can be forfeited when the Miller selected tenderer cannot Miller deposited the security money and made a Miller the agreement with the authority. As per Miller to close 11 of the Miller Rule 47 of the Assam Panchayat Financial. It provides that Miller. May I read Miller?
Yes.
On acceptance of the tender, the Panchayat concerned shall inform the selected tenderers concerned requiring the tenderers to submit within 7 days from the date of issuing the acceptance letter to deposit with the Panchayat concerned not less than 30% of his quoted amount in his tender as security and accept a duty stamp list in the form of
Yes.
specified in so and so.
What is the act?
Assam Panchayat.
Assam Panchayat Act.
Assam Panchayat Act. I've got here. Assam Panchayat Act.
And
Which provision?
the Assam Panchayat Financial Rules 2002.
Financial rule 2002. Yes. So which one? Which rule?
2000.
Rule number.
I know which
Rule
rule.
47. 47. That Miller lost me come to Miller to rule 11.
Sub rule
11. On acceptance to the tender, the Panchayat concerned shall inform the selected tenderers concerned requiring tenderers to submit within 7 days from the date of issuing the acceptance letter. Number A, 1, deposit with the Panchayat concerned not less than 30% of his quoted amount in this tender as security, and so on, so on, so then and accept a duty stamp in this so and so. Then
Then
Then sub rule 13.
So you're basically on
Sub rule 13.
11 and 11,
13.
12, 13.
Yes, ma'am.
11, 12, 13. Or 11 and 13 only. Which one?
11 is directed to submit the earnest money, deposit earnest money, and lease agreement. And on failure of those documents, then 13 will come in.
13, yes.
Failure of the tenderer to comply with the conditions set forth in sub clause 11, 1 and 2 shall result in forfeiture of the earnest money deposited in concerned concession. That is my answer here. Since my lord, I was not offered the settlement. I was asked to submit the lacking document as per clause 10. But the settlement was not offered to me. So, in view of sub rule 13, my earnest money cannot be forfeited. That is my submission.
Any citation?
This matter has not been decided.
Yes. What is the case?
Lordship, clause 11, 1 and 2, these are different provisions, not for as the clause 10, my lord. Clause 10 is different, my lord.
No, but these are rules for
Yes.
rules of procedure for sale and settlement of
Yes,
market.
yes, my lord.
Then
Lordship, clause 10 was introduced after the COVID, my lord. Before that, clause 10 was not there.
no, whether it's
Yes, yes, yes.
after or before,
Yes, yes.
that's not an
Yes, yes.
issue.
But there, yeah, in this clause 11 and 13, there were nowhere written that the other clauses we cannot forfeit it, my lord, because of other clauses. This is one of the rules for which we can forfeit his earnest money. He cannot say, my lord, that only because these rules will involve. Because clause 10 was very clear, my lord. Lordship may kindly come to page number 34 of my affidavit.
You see, one thing is
Resolution of
page,
the
page 30,
34
34.
of my affidavit, my lord. Running page 34.
Yeah.
This is the minutes of the meeting of the General Standing Committee, my lord. And after this only, my lord, he was offered, my lord. Decided to offer the settlement of said market in favor of Ruhul Amin, my lord. Being the second highest bidder, my lord. And next page, my lord, the second resolution, dated 29/7/21, it was decided he failed to deposit and forfeited his earnest money. And he very knowingly he participated in the tender, my lord, without challenging clause 10, and he have to comply with the condition of the clause 10. So respectfully, I am submitting, my lord, there is no merit, lordship may dismiss the petition.
This rule 4711 deals with
Yes.
the procedure to be followed on acceptance of the
Yes.
tender. Okay, now your case is prior to acceptance of the tender. So, is there any conflict between this 4711 and clause 10? Where is the conflict?
My submission to the lordship because my tender, even my tender was not accepted. Before that,
But then clause 10. So you mean to say clause 10 is hit by 4711?
yes, because that clause 10, the highest tender of the highest bidder, the tender of the highest bidder, and it is subsequently this honorable court held that the highest bid means valid highest bid. But my tender was lacking of document. So in view of clause 10, they given me 3 days time. I prayed for some more time to allow me to submit those documents. But they issued notice on 26th
and my lord rejected my claim on 29 within 3 days.
My lord, as per his own pleadings, my lord, his case is that he required more times, which he was denied. It's not a case that clause 10 is,
No, but then
Not a-
there is there's a question that arisen here. Can it be said that now supposing there are say 10 tenderers, say tenderers. The first one, because he does not submit, supposing he submits wrong document or some mandatory document which has to be submitted is not submitted. Can the respondents authorities, can they accept that tender? They cannot accept. If they don't accept, earnest money will have to be returned or not?
no, forfeited.
No. forfeit.
That is the objective of the earnest money.
So supposing someone, so if they don't submit, supposing there are 10 tenderers, supposing the sixth highest person, he does not submit any
In
document
that case, we will return to them.
if the first one is
Yes,
given.
yes, yes.
But they will, that means
Yes,
they will all,
The
they'll all
clause is
lose.
saying that if we offer and then refuse, then only we will forfeit it. Otherwise, what is the purpose of earnest money, my lord? I'm asking myself, my lord. What is the purpose of earnest money, my lord?
You tell us, please you ask
So
yourself.
objective is that, my lord, it is interest of the bidder. If you will not fulfill, then we can forfeit.
Let us see the definition of earnest money.
My lord.
From where do you get it?
The rule earnest money is not there, maybe in the act. Let me check it. Hmm? Act of money. There is no description.
Definition you mean?
Definition is not there.
I think some thought process will have to go into it. Right. Heard, Mr. D.A. Qayyum, learned counsel for the petitioner, as well as Mr. S. Datta, learned standing counsel, PNRD department. The petitioner's case is that the petitioner took part in the tender process for settlement of Bali Satara bi-weekly market for the year 2021-22. Vide NIT dated 10/5/2021. The highest bidder, what happened to the highest bidder?
He withdrawn the tender.
The highest bidder withdrew his tender, and the petitioner, who was the highest bidder, second highest bidder, was issued a letter dated 26/7/2021 directing him to submit the remaining documents in terms of the tender notice within 3 days. the said direction had been made on account of clause 10 of the NIT, which provides as follows. Page, where is that page?
Page 14, my lord.
Page 14, huh?
Yes.
Yes. Next para. The petitioner could not submit his document within 3 days and asked for further time to submit his document. However, the respondents overlooked the tender of the petitioner as he could not submit his tender documents within 3 days from the date of asking for the same, and awarded the tender to whom? And awarded the tender to
Settlement to one Onubhati, Secretary.
to another tender. Yes.
23.
Next para. The petitioner is aggrieved by the refusal on the part of the respondent to return back his earnest money. First off, he submits that clause 10, clause 7 and 10.
10.
To clause 10
10.
of the NIT dated 10/5/2021 cannot stand in the way of the respondents returning his earnest money, comma, inasmuch as, comma, the petitioner had not been selected as a tenderer in the absence of the required documents being furnished by him. Further, in terms of section 11 and 13 of the Assam Panchayat bracket financial rules 2002, earnest money could be forfeited only on account, only on two conditions not being fulfilled. Comma, that is, if the tenderer fails to deposit the required tender amount, is it? No, fails to deposit 30% of the quoted amount within the stipulated within 7 days from the date of his selection. And what is the second?
And
11-2.
and accept a duty stamp list. Same paragraph. my lord. Third line, fourth line.
Huh?
Clause 1, fourth line, and accept a duty stamp list. Deposit with the Panchayat concern not less than 30% of his quoted amount in his tender. as-
No, it's only 30%, that's all. What is it?
And
Huh?
and that is there.
Ah,
And accept the duty stamp list in the form
what
of
does this mean? And accept the duty stamp list. What does it mean?
the tenderer and the authority has to made a agreement.
Okay. And in the event the tenderer fails to provide the form of lease and stamp papers at the time of making the agreement, full stop. The said conditions for forfeiting an earnest forfeiting earnest money provided in provided in Rule 11 of the 2002 rules not not being present in clause 10 of the NIT, the earnest money would have to be returned to the petition. Correct?
Yes.
Next, so of course, then his case is that the next para, the counsel for the stand of the respondents on the other hand is that clause 10 of the NIT is not in conflict with clause with rule 11 and 13 of the 2002 rules.
And there is no word only.
Huh?
There is no word only, my lord, in 11 and 13, my lord. As per petitioner, this is the only.
But only.
As per petitioner, this is the only rule for forfeiture, my lord.
Uh-huh.
So my submission is that this is not the
First
only
off,
rule.
he submits that the clause 10 that the respondents have the competency and the right to insert clause 10 in the NIT for forfeiture of earnest money in addition to rule 11 and 13 of the 2002 rules.
And second ground is that he did not challenge the clause before submitting it. He participated. And when we forfeited, thereafter.
Okay. He further submits that the petitioner did not make a challenge to clause 10 of the NIT prior to participating in the tender process. As such, he cannot turn around and make a challenge to the said clause at this stage. Now, after the tenders have been opened. That's all.
And he even didn't challenge that he was denied the extension period. He did not challenge also. That period also not challenged.
First off, the counsel for the respondent further submits that the petitioner not having challenged, the petitioner having prayed for extension of time for submitting documents in terms of clause 10
Yes.
of the NIT, the petitioner cannot turn around and say that clause 10 would not be applicable to him. That's all.
Yes.
Any citations besides any citation? No. Huh?
It has not been decided.
Okay.
It's maybe 2-3 cases were there, but not reported and not with me, my lord. Because earlier also.
Can we fix a date? So do you try to get the citation?
The date can be fixed, my lord. If I can try.
We'll fix a date. If you can get to it and good, otherwise I'll
My
decide.
lord.
When? Friday?
Friday.
Please the matter on Friday. On which date the counsels for the parties shall try and obtain citations in support of their submissions.
Well.
Anyway, everything is there now. The only thing is
Yes,
that we have got to do citations or some. So I'm just giving you time, so it shortens my work.
My lord.
Obliged.
Item 28.
The respondent, they haven't filed their affidavit in opposition yet.
What is this? You want, who is appearing for the other side?
Last option also no one appeared.
Yes.
No,
Union
here
of
also,
India.
my lord, same issue is there, my lord, page 70. No, we have replied to the arbitration notice, page 70.
Huh?
Regarding appointment, my lord, we have stated that the claim raised is, my lord, 120.39% more than the contract agreement. Whereas the contract agreement stipulates that, my lord, 20% of the contract value.
Where is the provision here? That is like-
Here is, my lord, at page 56.
Okay, right,
My lord, 57, my lord.
57.
Yes, 57, my lord, 64.7, and sub-clause is 47.
Okay, right. Mr. H. Gupta, CGC submits that in terms of clause 60,
4.7, my lord, dash
64.7,
47.
64.7. Out here 47, 48. What is this? Out there it was
Malad-
10 point something.
My lord, this is there. How they
As
are
this a clause 64.7,
formulated, my lord.
comma. Claims that are less or equal to 20% of the value of the contract work are to be they are to be can be decided in terms of the Arbitration and Conciliation Act 1996. Full stop. However, claims having a value of more than 20% cannot be decided by arbitration. Full stop. He submits that the claim of the petitioner, the value of the claim of the petitioner is how much percent?
It is 120.39%.
120.39%
0.39.
of the contract value. Are you filing any affidavit?
The affidavit is not required, my lord.
Not required.
From FSI, my lord, and judgment, my lord, which I earlier like that. Then the High Court judgment.
Oh, you gave me earlier, no?
Lordship will fix it at 16, the other matters they are fixed at 16.
16. Okay, right. Mr.
A. Ahmed.
A. Ahmed, Learned Counsel shall obtain instructions with regard to the above. List the matter on 16th. Yes, what is your stand?
Your Worship, we have objection regarding the materiality of this petition before this honorable court.
Why?
Because there is a clause of seat, rather venue in the agreement. So the courts in the agreement stipulated that venue would be, arbitration venue would be in Mumbai. Now the question that arises before Lordship, whether venue would be equated with seat. This issue has been decided by the Honorable Apex Court in the year 2020. I brought the judgment where they said that be it seat or venue, the courts of that jurisdiction will have all supervisory jurisdiction, including 11(6). This judgment was relied by this Honorable High Court, where we were even the same party was respondent, because we are a tower infrastructure company, that Airtel, that cellular towers. So we have leased with many parties all over us.
I've seen the seat of arbitration.
Yes. So this judgment was because there also we had venue, same clause, same format agreements where only the parties' names are changed. So they also dispute regarding the rent, and they came before this honorable court. We were the respondent, relying on the.
Let us see the arbitration clause.
Yes, your Lordship, a type copy of page 36.
Page 36.
Yes.
Clause 22.
The arbitration shall be held
At Mumbai. Your Lordship, this is the Supreme Court judgment. Your Lordship may straight away, they discuss everything, and Lordship may come to
But there are some conflicting judgments also, no?
Yes, but this was relied by our High Court.
No, maybe relied, but then I want to know what the latest Supreme Court judgment.
But they decided to interpret the venue shows that.
No, I have read about this a long time back. I don't
That
remember.
was prior, this has been settled after the swastik case also, that venue shows the intention of the parties where they do want to have the arbitration. And that place should have the supervisory, that course of that jurisdiction should have the supervisory jurisdiction, including 11(6). or for even for interim order under section 9. Your lordship may see 18, 19, and 20. Okay, sir. No, no, wait a minute. If your lordship allows me, I may read.
Yes.
Where the contract specifies the jurisdiction of the court at a particular place, only such court will have the jurisdiction to deal with the matter, and the parties intended to exclude all other courts. In the present case, the parties have agreed that the venue of arbitration shall be at Bhubaneswar. Considering the agreement of the parties having Bhubaneswar as the venue of arbitration, the intention of the parties is to exclude all other courts. As held in Swastik, non-use of the words like exclusive jurisdiction, only, exclusive alone is not decisive and does not make any material difference. Next paragraph. When the parties have agreed to have the venue of arbitration at Bhubaneswar, the Madras High Court erred in assuming the jurisdiction under 11.6 of the Act, since only the Odisha High Court will have the jurisdiction to entertain petition filed under 11.6 of the Act. The impugn order is liable to be set aside. In the result, the impugn order is say, and the liberty is given to approach the Odisha High Court. And this was relied, same fact, same agreement. We were the respondent, your lordship. This our Guwahati High Court.
No, there are some judgments regarding seat and venue.
Venue. Where we were the parties, same, your lordship may see respondent number 1 and 2, GTL infrastructure.
No, it's okay.
So, right, so they gave the liberty to approach the Mumbai, they are also the.
Unfortunately, I don't remember those judgments.
Lordship, one judgment we are relying upon, well, paragraph 18 will be paid, our petition, well.
Yeah.
From our petition,
Okay,
paragraph 18, well,
18.
18, yes, well. Page 15, 1 5. Page 1 5, well.
Yes,
May I read, well.
yes.
The petitioner begs to state that Honorable Guwahati High Court, while decided the matter reported in 1999, 1 GLT 191, so and so, in paragraph 9, taken into consideration that, therefore, it has to be seen whether there is an arbitration clause in the agreement alleged to have been entered into by the parties, and the court at Shillong is competent to entertain the petition. Paragraph 22 of the agreement dated 8 December 1988 reads as follows. The arbitration shall be as per Indian Arbitration Act 1940, and jurisdiction shall be Shillong. Facts of that case was that the contract was for carrying different
Mr.
materials
Counsel,
from
this is a high court.
my
But please show him the Supreme Court judgment. Show him, just let him read. Just read the last three paragraphs, last three paragraphs. Last.
Yeah.
Okay.
Yes, my latest judgment, another judgment is there, my seventh judgment is, come from Honorable Supreme Court, decided on my lord 13 December 2023. Wherein my lord, one paragraph is there, was 7th judgment, my lord mentioned that preliminary issues can be decided under section, my lord 11 of the Arbitration Act. And the jurisdiction is a preliminary issue. Subject matter, my lord, is immovable property, and it is within the jurisdiction of my lord Dorong List of Assam. And my lord venue mentioned.
Show me.
Well, this is a curable petition, well, it comprised 7 judges under the Supreme Court. And in paragraph 140, there is an observation. 140. Well, issue raised here that unstampable agreement.
Para?
Paragraph 140, 140. 140.
How does, so how does this, how is this judgment saying something that is not here?
My lord, there is, we are arguing that there is a preliminary issue with regard.
What is the preliminary issue?
The jurisdiction is, it is preliminary issue. Well, subject matter is here.
Well,
Look,
no, don't. Sorry. You see, jurisdiction.
Yes.
With regard to what? Jurisdiction with regard to what?
with
Jurisdiction with regard to where the seat of arbitration would be. What do you mean by jurisdiction? Are you talking about the jurisdiction of the arbitrator? Or the jurisdiction with regard to where the seat of arbitration would be, or the venue of arbitration? What are you trying to say?
my lord, we are trying to say that this agreement is against the public policy. And
It is actually,
yes, well,
whatever dispute you have, that's a different issue.
yes,
Now the issue is that there's a provision in your arbitration agreement
yes,
that disputes will be referred to arbitration
yes.
and it will be in Bombay or where is that?
Mumbai, yes, well,
Mumbai. Now, when there's a specific state or jurisdiction conferred
yes.
where the seat of arbitration would be, then
We are,
how can I say, how can I decide
lordship,
that no, it should be, we should decide, the arbitrator's appointment should be decided by the Guwahati High Court. When the Supreme Court has said
my lord,
that once it says, Bhubaneswar, Madras High Court had no authority to appoint an arbitrator under Section 11. Who is the High Court compared to Supreme Court?
no, my lord, is matter, my lord, relates to arbitral tribunal, my lord. Arbitral tribunal will decide the, my lord, say.
Correct, but who will appoint that arbitrator?
Look, High Court will appoint the arbitrator.
High Court will appoint which High Court?
The jurisdictional High Court, my lord.
Jurisdictional High Court. Now, which is the jurisdictional High Court as per your contract agreement? As per your arbitration clause,
Yes, sir.
which is the jurisdictional High Court?
Subject matter in Assam, so,
Look, let us go again. Where is that page?
Page
36.
Yes, sir.
I think I've heard. Okay, right. No problem. Heard Mr.
K. Raman, my lord.
Huh?
K. Raman.
K. Raman, learned counsel for the petitioner. Also heard Mr.
R. Sharma,
R. Sharma, learned counsel for the
respondent, all the respondents.
also respondents. Good stuff. The petitioner has filed this application under Section 11 of the Arbitration and Conciliation Act, common hereinafter referred to as the 1996 Act. Praying for an arbitrator, praying for appointment of an arbitrator in view of, on the ground that there are disputes between the petitioner and the respondent pertaining to, where is that agreement of
Page
contract?
27,
Page 27 agreement.
pertaining to non-payment of rent as per the
Pertaining to
non-payment of rent.
non-payment of rent. Pursuant to the lease deed dated 9/7/2014. Next. The counsels for the parties submit that there is a dispute between the parties which would have to be decided by an arbitrator. However, the only difference of opinion between the counsels for the parties is that is with regard to whether this court should appoint an arbitrator or or the Mumbai High Court,
Bombay High.
Bombay High, Bombay High. Good stuff. Next. Clause 22 of the lease deed dated 9/7/2014, which provides for appointment of an arbitrator, states that the arbitration shall be held at Mumbai. The contents of clause 22 is reproduced below as follows. Next paragraph. In the case of Brahmani River Pellets Limited versus Kamachi Industries Limited, reported in 2025 SCC 462. The Supreme Court was to decide whether the Orissa High Court would have to appoint an arbitrator. Orissa High Court or Madras High Court would have to appoint an arbitrator in terms of Section 11(6) of the 1996 Act, inasmuch as the arbitration clause provided that the venue of arbitration would be at Bhubaneswar. Full stop. The Supreme Court held that when the parties have agreed to have the venue of arbitration at Bhubaneswar, the Madras High Court erred in assuming jurisdiction under Section 11(6) of the 1996 Act. It further held that since only the Orissa High Court would have jurisdiction to entertain a petition filed under Section 11(6) of the 1993 Act, the appointment of the arbitrator by the Madras High Court was liable to be set aside. The same was accordingly set aside. In the present case, the arbitration clause agreed to by the parties provides that the arbitration venue shall be held at Mumbai. In terms of the judgment of the Supreme Court in Brahmani River Pellets Limited Supra, the application for appointment of an arbitrator under Section 11(6) would have to be made by the petitioner. 11(6) of the 1993 Act would have to be made by the petitioner before the Bombay High Court. Accordingly, the present writ petition, arbitration petition stands.
My lord, just one date may be given, we, my lord, in our support, we try, they are relying upon, my lord, 2020 judgment. One judgment is, my lord, today we have not available, so my lord, another date may be fixed. On the next date, matter will be decided.
So the law has not changed, the law.
No, let it give us, let us give him a chance tomorrow.
But day after tomorrow, my lord, Friday. My lord.
I will fix too many. Okay, tomorrow we've got.
Friday or my lord.
Okay, day after tomorrow, list the matter. What have we said the last person? Accordingly. Dismiss with liberty to the petitioner to approach the Bombay High Court, if so advised. This is, we're keeping it in storage, ready for use. If you provide some other judgment,
Yes.
then we will change it.
My lord,
If not, this is kept.
lordship,
Ah,
oblige.
for Friday.
Friday or next week.
Many matters. No, Monday also many matters. Maybe this bench to be matters. That's why I'm completing the judgment, the
Lordship.
order. So that if you can get a judgment, good enough. If you
Well,
cannot,
Well, 13, cannot be on 13.
no, you have asked for a inch, we have given you
My
already a foot.
lordship.
No, not more than that.
Tomorrow, lordship, only he has to place the judgment. There is-
Correct, maybe better tomorrow. I'll list the matter tomorrow. You just bring one judgment. If it's a thing, then we'll decide.
Oblige,
Then we will adjourn the matter. Because then I'll have to decide.
oblige. Oblige.
So it's a sealed cover procedure right now.
Oblige.
Full bench is there. Wait. No, wait, not wrong. This is your foot, this also. Yes,
Lordship,
item
we will file
30.
reply affidavit, my lord.
Huh?
We will file reply affidavit.
And affidavit was filed yesterday, lordship.
We need 1 week, lordship.
Okay.
Kindly date.
Okay.
my lord. 15.
Mr.
N. Roman,
N. Raman appearing for the petitioner is granted a week's time to file
kindly fix that.
a week's time to file affidavit deposit, 2 weeks time to file affidavit in reply. List the matter.
Fix that, my lord, kindly. 23.
Here, my lord, the respondent wanted to file the affidavit. We like to file a reply. Today they filed the affidavit.
Okay.
I pay for 3 weeks time to file the affidavit.
2 weeks time. Okay, Mr. B. Gogoi, that is,
2 weeks time.
huh?
2 weeks time.
No, you take 3 weeks also, no problem. No problem. If you want 3 weeks, we'll give you 3 weeks.
No, they are upset.
I will give you 3 weeks, no problem. This it's all the cases are getting jammed.
3 weeks in that case.
Basically, it's with regard to the cancellation of it.
Cancellation. Now they are.
Now
taking
you have got the proper land you have got. You have changed it.
That's why they now they are.
So why do you want to file affidavit? I don't understand.
No, they are now, my lord, in the affidavit opposition, they are now taking some different step.
Different stand?
Yes,
Oh,
referring to some complaints of 2020, which has been inquired into and it was in our favor. All these have been stated in the affidavit.
okay. Mr. B. Gogoi submits that. Mr. B. Gogoi, learned counsel for the petitioner, is granted 3 weeks time to file affidavit in opposition to the affidavit in opposition filed by the
One and two.
PCB.
Yes, PCB.
PCB today.
Fine.
This is the matter of the speech.
Fine.
Yes,
We are waiting for instruction, my lord. We need some time. my lord.
no one appears for the petitioner on call. Mr. M. Chetia, learned counsel for the
For the respondent, my lord, respondent name number.
PCB. Who's for the PCB?
Yes, Boro APS, my lord. I am for respondent of 5 and 8, my lord.
Who is to file the affidavit?
I need some instruction, my lord, why my lord fix in factory has been.
Huh? No, who is the
I'll find out deputy commissioner, my lord. Deputy commissioner,
he's the one who closed it.
yes, my lord.
Okay. Mr. M. Chetia, appearing for the,
Similar case, my lord, this coordinated bench of this court, my lord, get passed over. order.
Okay.
Yes.
Yes, my lord, that can also be done, my lord.
No, but who, where is the order, impute order?
Imperial order, my lord, the page, my lord, 61.
But this is by the deputy commissioner's office.
Yes, my lord.
Yes, sir.
After my perusal of the detailed inquiry report, please, to have reacted, my lord.
They obtained, my lord, they obtained the certificates and permission, my lord, and they submitted before the before the deputy commissioner. Kindly see, my lord, page 64. But that has not been considered. My lord, order dated,
Has the deputy commissioner got the competency to issue orders for violation of this rules? Anyway, this order,
yes,
but you have not, it has not set aside the.
yes, no, not sir.
Then,
No, sir.
then this order is not complete. The deputy commissioner's order would have to be set aside.
Yes,
You see, now the deputy commissioner has closed the brick field due to grievance raised by the residents, okay, of the village. And okay, detailed report has been made. And report is basically with regard to the stone crushes or brick kiln?
brick field,
Brick
1 and
kiln.
2 brick field,
Brick kiln,
and others.
brick kiln being running, functioning in violation of the rules under the Assam Stone Crusher Establishment and Assam Brick Kiln Establishment.
Yes.
Now, these, who are the authorities under these rules to decide whether this brick kiln can be run? Is it the deputy commissioner? Where are the rules?
Rule is there.
I have to go to that.
If it is not the deputy commissioner, then those authorities will have to decide.
My lord, pollution control board, my lord, they issue some no objection certificate. Thereafter, my lord, deputy commissioner. Then.
That's what. So I want to know how this out here it says to approach the competent licensing authority under the Assam Stone Crusher Establishment and Regulation Rules. Let us see these rules.
Yes,
There is,
I have not an explanation. It's not an explanation.
Eastern Pakistan.
Doesn't matter. Like,
I think they have.
out here, it can be only allowed by the concerned circle officer of the revenue department of the government.
yes,
So the circle officer will be under the deputy commissioner.
Yes.
Then. So where is the question of going to them? Because they have now set aside. Now what about the other law? What about the Assam Brick Tin Establishment and Regulation Rules? Where is that?
that is there. my lord. This,
This is the one.
yes,
And your case is with regard to stone crushers? No.
no, my lord. Earlier it was a stone castle.
Okay, now don't do it.
This, instead, my lord, it is brick mix. So, my lord, petitioners say having all the documents, my lord, relevant requisite documents now. At that time, my lord, when the order was passed, some lacking of documents are there. Only for that reason, my lord,
industry
yes, my lord.
was closed. But thereafter,
My lord, that order is, my lord, reasonable.
So there is nothing wrong with the order then.
Yes, my lord.
but thereafter, my lord, petitioner obtained all the documents.
So
from
what? Then
the-
you make a fresh application.
Yes.
Yes, my lord. And kindly see, my lord, page
No, so you see,
62, my lord, kindly.
no, Mr. Counsel,
Yes, ma'am.
it's very simple. You have challenged the order closing your brick clinic,
Yes, ma'am.
but you have also admitted right now that you did not have the proper documents.
Right, ma'am.
So your writ petition fails because you have not been able to show that there was any wrong in the order. Correct? There's nothing
No,
wrong
my
in the
lord,
order.
kindly see page 62, there is some point, my lord. kindly
Yes.
see. Last paragraph, my lord.
Yeah.
Therefore, being satisfied with the inquiry report and emergent nature of the environmental impact, the closure and sealing of the above mentioned industries operating at the so and so village and the so and so is hereby ordered. These industries are moreover directed to submit to the office of the undersigned.
That's
all
what I'm,
deposits
that's what I'm saying.
thereafter, my lord, the petitioner submitted the documents. Page
Okay.
64, my lord. Page 64. On 4/10/23, these documents were submitted before the before the district commissioner Udalguri, my lord, but that has not been considered and did not allow the petitioners to, my lord, operate their building.
But they have not rejected your bid, your prayer. Have they rejected?
No, my lord, it is pending, my lord.
Yes, sir, it's pending.
Yes, pending.
So you take a decision.
Yes, that will do.
That's all. What is that?
Yes.
Yes, my lord. If already decision has not been taken, my lord, since I have not received.
Correct,
Ah,
correct.
yes.
But this writ petition fails.
Yes.
There's no question of setting aside that order.
Yes.
There's nothing wrong. Okay, right. Heard, Mr.
RF Chowhan.
R.S. Chauhan, Learned Counsel for the petitioner. First have also heard Mr. M. Chetia for
Yes, one number 5 and 8, my lord.
5 and 8. Who else? Ms. R. Devi for 1. Mr. B. Chakrabarti for B. Chaudhary for 3 and 7. And Mr. and Khaira for 2 and 6. Full stop. The petitioners are aggrieved by an order dated 16/3/23 passed by the Deputy Commissioner, Udalguri, bracket BTR, whereby the brick kiln industries of the two petitioners have been ordered closure on the basis of an inquiry caused pursuant to a public complaint. Full stop. The impugned order dated 16/3/23 states that on perusal of the detailed inquiry report, it is evident that the six stone crushers,
Brick 1, 2. Page 62, my lord, 1 and 2. Kindly see, my lord, page 62. 1 and
that the brick kiln industries operating at Gorubanda village, two brick kiln industries operating at Gorubanda village under Masbat Revenue Circle have been functioning without necessary authorization from the concerned authorities in violation of the Assam Brick Kiln Establishment and Regulation Rules, 2013. Further, there is a lack of there is no clearance from the Pollution Control Board, Assam. Full stop. Next para. The petitioner's counsel submits that at the time the impugned order dated 16/3/23 was issued by the Deputy Commissioner's office, the petitioner did not have the required documents for running the brick kiln. Some naturally required means some. For running the brick kiln industries. Full stop. However, the petitioner has now acquired all the necessary documents for running the industries and has submitted the same to the District Commissioner Udalguri wide forwarding letter dated 4/10/2023. However, no decision has been taken by the District Commissioner Udalgiri to allow the petitioners to continue to run the brick tin industries. He accordingly prays that a direction may be issued to the District Commissioner to take a decision on the petitioner's application for running the industry, application dated 4/10/23 to run the aforesaid industries. Full stop. Mr. M. Chetya, learned counsel for the, no, this is the counsel for the respondents. Submit that they have got no objection to the prayer made by the petitioner's counsel. Full stop. Next para. On perusing the pleadings and after hearing the counsel for the parties, it is quite clear that there is no infirmity with the impugned order dated 16/3/23 passed by the District Commissioner / Deputy Commissioner Udalgiri. In closing, in ordering closure of the petitioner's brick tin industries. However, the last sentence of the impugned order dated 16/3/23 provides as follows, inverted commas. These industries are moreover directed to submit to the office of the undersigned all requisite clearances, NOC and permission as per relevant rules from the concerned authorities within a time period of 4 weeks. Commas closed. Next paragraph. As the petitioners have apparently submitted their documents for running the brick tin industries, the District / Deputy Commissioner Udalgiri is directed to take a decision on the petitioner's representations dated 4/10/23.
23.
23. And communicate the same to the petitioner. The entire process should be concluded within a period of 2 months.
1 month.
1 month. I said 2 months, you said 1 month. Okay. 1 month from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed of. Okay.
36.
Give it to him.
My pleasure. This petition is filed checking for non-payment of contractual bill charge. This case, the petitioner has been awarded.
Is it admitted?
It has not been admitted, but your lordship, I have filed various, petitioner filed various representation.
No representation. Yes, what is the instruction?
We have not received any
You
instruction.
received instructions, okay, right? No. Huh?
Drafted similar.
No, I'm not going to ask for that verification. Yes, Mr.
C. Sharma, lordship.
C. Sharma, the counsel for the
Respondent number 1 to 4.
1 to 4. And who else? And Mr. R.K. Talukdar for respondent number 7 shall obtain instructions and.
Lordship, I have no role to play, Lordship.
I
have no department.
Okay, Mr. 1 to 4, shall obtain instructions
It may be fixed.
and file affidavit if necessary within a period of
3 weeks, sir.
3 weeks. This is a matter after 3 weeks.
It may be fixed, Your Honor.
When the matter pertains to which period?
Lordship, the work order issued right from period 2012.
12.
Subsequently down to 15, Your Honor.
And when did you come to this court?
2023.
After 11 years. So why sudden hurry?
37.
Similar order may pass in 37.
29.
Very limited issues in this petition lawsuit.
Yes, what is it?
Petitioner was settled with the fishery lordship, then petitioner approached the fishery corporation for proper demarcation and encroachment, removal of encroachment lordship. Then lordship fishery department annexed A, page 13, communicated the letter to the district commissioner. Annexed A, page 13 lordship, for doing needful for proper demarcation and removal of encroachment lordship.
Yes.
Yes, my lord. I have not received any instruction whether demarcation has been done or
Not done, yes, okay. I mean,
Demarcation not done, encroachments are still there
yes,
and probably eating his fish also.
yes.
Yes, sir, may be issued for demarcate, my lord.
Huh?
Already, since my lord letter has been issued already.
And representation is also pending, page 15 lordship, I have approached annexing these two letters lordship.
Okay, right. Heard, Mr.
MK Hussain.
MK Hussain, learned counsel for the petitioner. Kusam also heard Mr. M. Chetia, learned
Correspondent
counsel
number-
for the respondent number 3 and 4.
3 and 4, my lord.
And R. Chetri. Chetri. Nepali. Okay, R. Chetri for respondent number 1 and 2. Out here written R. Chetia, that's what I was thinking.
M. Setia.
Your M. Chetia, his name was R. Chetia. He's Chetri, no?
Set.
Chetri, huh? No, for respondent number 1 and 2. Full stop. The petitioner's case is that he was settled with the Garalu Meen Mahal under Moregaon district for 7 years with effect from 1/4/22 to 31/3/29 pursuant to NIT dated
3622 lordship.
3/6/22. Full stop. The petitioner made various representations to the authorities claiming that there were encroachments in the settled mahal for which, he was not able to operate the fishery properly. Full stop. Further, the respondents were requested to demarcate the mahal, which has not been done so till date. Full stop. He accordingly prays for a direction to be issued to the respondent authorities to demarcate the Garalu Meen Mahal. That's enough.
Lordship, respondent 3 and 4 lordship, they are the revenue.
So once they demarcate, that's enough.
Lordship, demarcate and encroachment lordship, little bit of encroachment.
Full stop. We do not know if it's a little bit, maybe thousands, then what to do?
They may examine and lordship, examine and then.
Next, right. He submits that, what have I said, the last sentence? Full stop. He accordingly prays for a direction to be issued to the respondents number 3 and 4 to demarcate Garalu Meen Mahal and evict any encroachers residing within the said area. Full stop. Mr. M. Chetty, the counsel for the respondents submit that they do not have any objection. Or what?
Yes, my lord, demarcation can be done, my lord. Yes,
Submit that. They do not have any objection with regard to demarcation of the Garalu Meen Mahal.
Okay.
First of, however, the question of encroachment, but
Getting question of enforcement, my lord. That will be examined by the authority, my lord.
however, the question of encroachment would have to be examined and a decision taken separately
Yes.
by the authorities concerned. Full stop. Next paragraph. On considering the prayer made by the petitioner and keeping in view the submissions made by the counsel for the respondents, the respondents number 3 and 4 are directed to demarcate Garalu Meen Mahal under Moregaon district within a period of
In a period of, my lord, 4 weeks, my lord, or 2 months, 2 months, my lord. Demand is 2 months. Notice.
Within a period of 2 months from the date of receipt of a certified copy of the contract. Full stop. The response number 3 and 4 shall also look into the issue of encroachment in the demarcated fishery, Garalu meanwhile, thereafter. And make appropriate decisions thereafter. And take appropriate decisions thereafter. Writ petitions accordingly disposed of.
I understand this matter had come up before your lordship day before yesterday. And upon going through the brief, upon going through the brief, I was wondering why my services were required. Then I went through the video. Perhaps my young friend got a little carried away and overlooked did not place a few relevant facts. May I just place the basic facts? The matter pertains to 6 different contracts that were executed by the petitioner. These 6 contracts were part of a larger project. As your lordship is aware, just to take an example, if we go from Tezpur,
No, I get it. They are broken up.
They segregate the project into separate contracts, and accordingly, tenders are invited and contracts are awarded. Identically,
So they're given different package numbers.
Yes, exactly. So that is exactly what had happened. This package was split into 53 different contracts. Out of these 53 contracts, the petitioner was selected for 15 contracts. And this particular writ petition pertains to 6 of those contracts, which have been successfully completed. Completion certificates have been issued separately. There were separate agreements, separate work orders, separate completion.
Where are those?
I'll place them precisely. If your lordship will first come to the writ petition, your lordship will kindly have, there are multiple affidavits filed, my lord. I'll place each of those and also the stand taken by the respondents. If your lordship will first come to page 16 of the writ petition, your lordship will find 6 different work orders have been issued. From page 16 to page 21. If your lordship just takes up page 16 for a moment, my lord, the overall project is called.
This case pertains to only 6 contracts.
Only 6 contracts.
You are saying 12. You are saying 12. That's why I put in the order of the 12. 12 work orders.
It's not one. That is why I said, I started off by saying perhaps my young friend, perhaps my young friend got a little carried away while placing the facts. Your lordship will find at page 16, improvement of, in the second sentence.
I got it.
Improvement of BBDC road.
Okay,
that
then
is the main.
page 16,
And
page 17.
Page 17 and up to page 21. Your lordship will find there are 6 separate work orders.
Wait. 18 is not a work order.
This is in respect of this. They did not have the work order. They have annexed the first page of the contract itself, contract agreement. But the work completion certificate has been.
But this pertains to what? BBDC repairing work.
Repairing works from right in the middle, your lordship will find in that same project, the contract is this: repairing works from chainage 0.00 meters to 23,000 meters.
Then
that is the contract. And likewise, my lord, your lordship will find up to page 21. These are the 6 work orders.
Yes.
Now, if your lordship, there is an additional affidavit filed today. If your lordship will kindly take up that, we have annexed the separate contract agreements. These start from page 65 onwards. No. 71 onwards. Internal page will be page 11. These are the copies of the relevant pages of the tender agreements that were executed. Separate agreements in respect of each of the 6 packages.
Yeah, okay.
Page 71 to up to page.
Okay, so basically there are 6 contracts.
Yes.
Unpaid dues are there.
And your lordship will find the completion certificates in the writ petition again.
No, no, completion, okay, completion. Now the question is whether the amounts are admitted.
Now, once the completion certificate has been issued, now what has been, I will place that also. Page 22 onwards are separate completion certificates in the writ petition. Your lordship will find in respect of each of these 6 contracts, separate completion certificates have been issued, which means the works have been successfully completed. Now they not only stop at that, they prepare a demand, which your lordship will find at page 28 of the writ petition.
28, yes.
These 6 contracts are from serial number 3 to 7 and serial number 11. And in respect of each of these, the department itself has sought for the funds for these completed works. Your lordship will find in the extreme right-hand column remarks, serial number 3 completed, serial number 4 completed. Your lordship will find up to serial number 7 all completed works, and serial number 11 again completed. And in respect of some others, payments have already been made where they were completed. It is only in respect of these 6 contracts that the payments have not been made so far. Now, as recently as 2023, another demand has been placed, which we have placed again in the additional affidavit. If your lordship kindly comes to the additional affidavit at page 65, at the very top of page 65, your lordship will kindly see the heading, demand proposal for grant share of NLCPR scheme. And the last page of that is at page 70, and your lordship will kindly note the date, madam. 24/3/2023.
Huh?
At page 70, your lordship will find the date. The date of this proposal is 24/3/23. It is slightly in a complicated handwriting, but my specific instruction is that it is 23.
Yes,
Now,
sir.
these 6 contracts, your lordship will find at page 68. Serial number 32, serial number 33, serial number 34, 35, 38, and thereafter in the next page, 41. And in respect of each of these, again in the extreme right-hand column, your lordship will find remarks column, work completed, work completed, work completed. So these are not documents randomly we have produced. These are documents issued by the executive engineer, countersigned by the additional chief engineer. At page 670, your lordship will find that these are clear admissions that the work has been completed. Otherwise, why would they ask for release of funds? And part payments have also been made. Now, in this context, madam, your lordship will kindly test the stand of the authority. They take a very interesting, 3 different affidavits have been filed and 3 different interesting stands have been taken. Your lordship will first come to the affidavit dated 30/11/22. And at paragraph 6,
Just a minute.
it should, as per the running page, it should start at page.
Affidavit of, this point number 6, yes. Additional affidavit.
It is a affidavit in opposition by the respondent number 6, filed on 30th of November 2020.
Yes, yes.
And your lordship will kindly come to para 6. The stand that they take is in para 6. Very interesting. This forms part of the overall project, but it's a completely separate contract altogether. What they say is this, that pursuant to the signing of the contract for improvement of BBDC road under NLCPR for the year 2008-9, the petitioner was allotted the work from chainage 9,000 to 14,450. Your lordship will kindly note this. This is a completely separate contract for which we have not preferred the writ petition at all. At a bid price of 5 crores, etc., etc. But the petitioner failed to proceed with the work, and despite issuance of several notices for execution of the work The petitioner did not execute the work. The petitioner also did not pay any attention to the work despite receipt of notice to execute the work. This is not an issue before your lordship at all in this writ petition. This is the first stand. In the second affidavit, they now, your lordship, the second affidavit is dated 31/7/23.
Yes.
Here, in a very subtle way, they try to shift the burden to the center. Paragraph 5. That the central share of the project was released in installments. The first installment was released on 4/2/2012, second installment on 30/12/2013, third installment on 8/11/2016, and the last installment was received on 6/10/28. I don't know how it can be 20. The balanced central share of so-and-so has not been released, and without receiving the central share, the deponent is not in a position to entertain the claim of the petitioner for payment of the dues which he claims after 13 years of issuance of the work. Now, we are not asking the deponent to pay. We are asking the state to pay. We are certainly not trying to put the burden on deponent in his personal capacity. Now, your lordship comes to the last affidavit, filed on 14/11/2023. Here, another interesting, again, they talk about central share, state share, donor, this, that. Paragraph 4 at page 56. I am just reading out the last sentence of the paragraph. Your lordship will read this sentence. Target date of completion of the project was June 2011, and the time frame was required to be followed strictly. Work orders were issued in 2015. How could we have possibly completed the work in 2011? But basically, what they have been trying to do is filing multiple affidavits, improve upon the record, which your lordship is aware. Mohinder Singh Gill absolutely prohibits that you cannot improve upon your records by filing subsequent affidavits. The admitted position is, as recently as in 2023, you have yourself asked for funds saying that these works have been completed. You have issued completion certificates. These are obviously admitted outstanding dues. And the law, well, I need not reiterate, your lordship is aware of it. The law with regard to the contractual obligations of the state is otherwise very clear. When in a tender process at the inception, in a tender process when there is violation of Article 14 and 19(1)(g), your lordships intervene. Otherwise, your lordships do not even enter into this arena. And when it is an admitted outstanding due, your lordships issue direction instead of relegating them to civil courts or arbitration. But just for my satisfaction, if your lordship so desires, I can place those judgments. First judgment I'm placing is my Lord Mohinder Singh Gill, that you cannot improve upon the record. I'm just giving the citation for your lordship's convenience. I'm not even placing it. 1978. 78 1 SSC 405, and the relevant paragraph is para 8. So it's the apex court ends up by saying that it is not like old wine that it will go on getting better. Now, the disputes that are being sought to be raised, urging upon your lordship not to enter the writ petition. These kinds of disputes were sought to be raised in multiple proceedings before the apex court as well as this honorable court. And the apex court as well as this honorable court has said that hypothetically, if you create disputes, that will not constitute a dispute. The dispute has to be real. So one of the judgments, your lordship is aware of ABL International case, 2004, volume 3 SCC. And in 2004, volume 3 SCC 553. Again, I won't trouble your lordship with the entire judgment. I'm just placing para 27.
What do they say?
Para 27, at page 572. entire case law has been discussed up to page, para 26. Now 27, this is what has been held. From the above discussion of ours, the following legal principles emerge as to the maintainability of a writ petition. In an appropriate case, a writ petition as against the state or an instrumentality of a state arising out of a contractual obligation is maintainable. Next is very important. This is what I'm placing reliance on. Merely because some disputed questions of fact arise for consideration, same cannot be a ground to refuse to entertain a writ petition in all cases as a matter of rule. Now, next matter, a writ petition involving a consequential relief of monetary claim is also maintainable. Now, based on relying on all these, again, recently the issue came up as recently as in 2023. And my Lord, Justice K.M. Joseph and Justice Rishikesh Roy have rendered a detailed judgment. This is my Lord 2023, Volume 2 SCC 703. And at para 82, the parameters have been laid down. And here, my Lord, I am relying on two of the parameters laid down by the Apex Code. Para 82, subpara 3. This is, my Lord, 2023 2 SCC 703.
2020?
2023 2 SCC 703. Paragraphs are para 82.3 and 82.6. 82.3 reads like this. The mere fact that the relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract if the complaining party is able to establish that the action inaction is per se arbitrary. Now, the next 82.6, without intending to be exhaustive, it may include the relief of seeking payment of amounts due to the aggrieved party from the state. The state can indeed be called upon to honor its obligations of making payment, unless it be that there is serious and genuine dispute. It is only when the dispute is of very serious nature and it is genuine, raised relating to the liability of the state to make the payment. Such dispute ordinarily would include the contention that the aggrieved party has not fulfilled its obligation. So the only opening they would have to ward off a claim for settlement of the unpaid dues is if the aggrieved party has not fulfilled its obligation. Now their own documents show that we have successfully completed the work. And the court finds that such a contention by the state is not a mere ruse or a pretense. It cannot be by way of a mere ruse or a pretense that they come up with a dispute. Now, there is a judgment of our High Court, my Lord, Division Bench. Here, my Lord, the Honorable Single Judge had rejected the claim on the ground that there is arbitration. And here it was found that the claim itself, your Lordship, I'm sure is aware of this judgment, my Lord. This pertains to Agartala bench, rendered by Justice R.B. Mishra and A.B. Pal. Again, relying on all the earlier case laws. And the relevant paragraph is paragraph 16. It is 2007, volume 2 GLT, 173. Here also, my Lord, ABL, etc. has been discussed. Z Telefilms, ABL, everything has been, Gunwant Kaur, everything has been discussed. And in paragraph 16, this is what has been held. Has my Lord got it?
Yes.
Para 16. We have heard learned counsel for the parties and have perused the documents on record and also perused the impugned order of the learned single judge. In our respectful consideration, in the present case, there was no serious dispute of facts involved in the agreement between the parties. Only claim was for non-payment of some remaining amount. The writ petitioner appellant herein had come forward by way of a writ for rightful claim or demand of full amount. The writ petitioner had claimed for the payment of agreed amount in reference to supply of agricultural items. And in that regard, communication was made by the writ petitioner. However, when the state authorities maintained silence in those circumstances, the writ petition was preferred, seeking appropriate direction for directing the state authorities to make full payment as in reference to the NIT. I'm skipping that portion, my Lord, your Lordship may skip that portion. The last sentence, there's a sentence starting for that purpose.
Yes.
For that purpose, the writ petition could have been entertained and there has been no necessity to refer the matter to the arbitrator, as no such dispute for interpretation of contract or its terms or controversial facts was involved, which could have been referred to the arbitrator. Here, my lord, again, the state had urged that there is an arbitration clause. Therefore, further urged upon this honorable court that the writ petition should not be entertained. But likewise, in fact, my lord, again, there's a judgment of the apex court, Tantia Construction, where in spite of existence of an arbitration clause, writ petition was entertained, and this is a case I had placed. In fact, my lord, very interestingly, my young friend here brought to my notice a judgment that was placed by the opposite side, rendered by the Supreme Court, Puna Hinda. I don't know whether your lordship recalls. That is a judgment sitting singly. Your lordship had passed the judgment in Itanagar, and I had argued the matter. That is the judgment that has been there. There were certain issues which in the single bench, your lordship had passed an order saying that in spite of the arbitration clause, it would be maintainable. It was upheld by the division bench. Ultimately, when it went to the apex court, there certain further issues arose, where the apex court felt that these are issues which cannot be entertained by a writ court, because they will require adducing of evidence, etc. Therefore, the matter was referred to arbitration. And in that very case, I had placed this Tantia Construction also, and your lordship had accepted my argument based on Tantia Construction. This is what I'm placing before your lordship. 2011 5 SCC 697. Para 11 will indicate that there was an arbitration clause. I'm sorry, well, para 15. It was also submitted that the agreement between the parties provided for arbitration in respect of all disputes and differences of any kind arising out of or in connection with the contract, whether during the progress of work or after its completion, and whether before or after the termination of the contract. It was urged that in view of the said arbitration clause, the writ court was not competent to decide the issue involved in the dispute, which had been raised by the respondent company. Now, if your lordship kindly come to para 33. Apart, has my lord got it? Para 33. Apart from the above, even on the question of maintainability of the writ petition on account.
Why you bring this?
Because now they are also trying to urge that, although it is not a pleaded case, in the written argument that has been submitted, they are trying to now say that there is arbitration clause, it should be relegated. But I just wanted to cover that up also, so that there's no. And Tantia Construction squarely deals with that area. The idea is, my lord, if it is.
No, where are they said? You have submitted a written argument.
My lord, earlier we have submitted for subject copy also, my lord, that it is on the basis of the, my lord, contract.
We will wait to that.
So, my lord, my simple prayer before your lordship is, my lord, based on their materials, the completion certificate is something not I would have a role to play in. They have issued the completion certificate, 6 separate completion certificates for the 6 different contracts. They have raised twice, not once, twice they have sent proposals asking for funds for, and they clearly indicate that the work has been completed. And one is as recently as in 2023. So would it be even open to them to make an attempt to raise any hypothetical disputes before your lordship? Unless they dispute their own documents, they have to first dispute those documents issued by them. Otherwise, any other dispute would be purely hypothetical. And that is what the apex court has said, that if it is of a non-serious nature and if it is not genuine, merely saying that there is a dispute will not constitute a dispute. So that is my limited submission before your lordship. And you're considering the undisputed materials before your lordship will issue a direction that within a time frame they will make the payment. Regarding filing of affidavit, my lord, as per the transfer early, my lord, honorable court directors to file the affidavit by the head of the department whether the admission amount is admitted or not. So the affidavit was filed. And regarding my lord, execution of work, my lord, not my lord, 12 works were allotted to the petitioner. Petitioner,
They are claiming only 6, right?
only in this particular petition 6, if they have filed the, my lord, affidavit, lordship will look into it, my lord, my lord.
No, no.
Only, my lord, just a moment, my lord. The lordship will look into, my lord, 12 works, that is from page 68. Today's affidavit, just my lord, lordship will look into it.
Page 68.
Page 68, serial number 31. My lord, column number 10, JK Construction.
Please.
My lord, JK Construction, my lord.
That is not, we
No,
are not
not
claiming
related.
anything.
No, my
That
lord.
does not form part of
My
the
lord.
6 contracts.
My
Let
lord.
us be clear about that.
My lord, I'm saying.
But what is this page 68? Page 68, I've got this para 5, you mean?
No, my lord, they have filed today, my lord, today's
Additional
affidavit.
affidavit. file.
Additional affidavit today filed.
There's a chart, my lord, page 60.
This is page, okay, 68. Okay, yes.
My lord, serial number 31, JK Construction. RA work photos.
Will you take 5 minutes?
Oh, my lord, 5 minutes. My
Because
lord,
I've got a meeting, that's the
my
problem.
lord, the works, that was my lord, major construction work amounting to rupees 1,68 lakhs. They did not start the work, my lord. And that is
They're
my
not
lord.
claiming also.
No, my lord, not claiming, but it is a single project, not like the national highway. It is separately issued by the, my lord, central government. Only a single project was issued by the central government from 1 to 31 kilometers.
Okay, so what you're trying to say is,
That if
They-
the
they-
petitioner
they-
failed to complete one work for a single project, whether the other works, if the central government is not a party and they are not granting fund, whether the autonomous council is required to pay the amount, required to pay the amount, my lord. At the condition of the terms and conditions provides that it depends upon the availability of the fund. If the fund is not given by the central government for that particular project, after foreclosure, whether they can we are bound to make the payment without receiving the fund from the central government. Why the fund will come?
that is your headache.
My lord.
Why did you make him work?
My lord, no, my lord, that is the one works, my lord. He has sufficiently, my lord, he has not completed the work. That is the, my lord, he has filed this petition only for 6 works. The other 3 works for which that is the reason for foreclosure of the, my lord, project. my lord.
Foreclose it.
We have already foreclosed it and another contractor has already been given the work. He has completed it, my lord. And the whole work 1 to 31 kilometers, not only the portion, whole work completed by the another contractor, my lord. But yeah, that is by the state government, my lord, not by the autonomous council. It is the central government project. Central share was given to us, state share was given to us. Central share, we could not get the central share as they could not complete the project due to the failure of the part of the petitioner that the major work he has not completed. That is my submission, and the condition is that arbitration clause is there. And there is another point is the payment is subject to availability of fund. Despite the order passed by the court on 15/11, they have not met the central government as a party. That without the central government stand that they will.
Was the agreement executed? Was the central government a party to the agreement?
My lord, as the project is of central government and the work order is like that.
You see, you get loans from the World Bank.
My lord.
To do a lot of projects in India. You will to make the World Bank a party, government of Japan a party.
My lord, but as the fund is required to be, my lord, I'm getting.
Maybe.
But it is the point. My lord. There is some.
I don't know, there's no time.
That is a submission. Let's consider all this as.
The thing is, I like to dictate a little bit, otherwise I forget. I don't like to keep it part heard. I mean, I don't like to keep it CAV too much. If it's
Your lordship can keep it for tomorrow morning.
tomorrow's what? 2 benches plus only that I've got a lot of work tomorrow.
In that case.
But we'll keep it. We'll try to. I've heard it basically.
Your lordship can in that case keep it on next Tuesday or next Thursday. It will be a hearing day later on your lordship's board.
We can try. We'll put it Thursday. Huh?
Thursday.
Let's say list the matter on Thursday. Because just for dictating.
Yes.
The thing is that I want you all to be there at the time dictation, at least at the facts. The last portion, I can do it on my own.
Apparently, there is also another similar matter which is.
Which was reserved by your lordship. Yeah, the same, my lord, same thing, exactly the same.
Yes, same. I was planning to dismiss that thing.
Won't do that.
So you see, one thing is that in this case also, now you see the order that we have written. List of so where Mr. P. Mahanta shall produce all the 12 contract agreements.
Not 12, 6.
That is what, now why did I write this?
My fault, my lord.
Why did I write this? I wrote this because
why I-
everything was projected as 12. Now, what you have brought, what you have submitted is completely different.
And in fact,
6 contracts, and
that
you have
is-
shown me 6 work orders. So that's why we asked him to get 12 contracts.
Yesterday, I went through the video clipping and I realized that my friend got a little carried away.
Sincere apology.
So you see, it takes you off the well-trodden path. And then you're left somewhere in some forest and you don't know how to get out. Let us see how much we can do. Let us see. But we cannot take too much time. I've got meeting.
But this is the matter wherein, on last occasion,
Huh?
the lordship, on last occasion, the lordship has directed the PWD department to file affidavit by yesterday, but they have not filed. And,
Where are they? Where's the PWD?
was there.
Okay. Paul, next. Yes,
May I please?
yes.
I am licensed you.
Mr. Council, have you taken dusty service? Yes, you are supposed to serve notice by way of dusty service. चलो बुलाएगा. They keep on shaking this chair. Okay, this is item number
39.
39. Oh, 39. Sorry, 39. Okay, fair price shop, yes. So,
39 Lordship, we need some time, Lordship.
okay, Mr. Mr. K. Gogoi is granted. How much time?
2 weeks.
2 weeks I have to file affidavit in opposition. This is the matter of 2 weeks. Next. Yes,
May I please, your lordship, today we have received the affidavit in opposition. So we would like to file and reply. to
Mr.
that. And Sharma.
M. Sharma, counsel for the petition is granted. 2 weeks I have to file affidavit in reply. This is the matter of 2 weeks.
You want.
Well, I is there, my lord. For, my lord, sorry, the last time, my lord, the government advocate was directed to take instruction why the deputy commissioner has not issued the license. Because I have deposited the license fee as well as security amount, 4 lakhs rupees. So, my lord, government has cleared everything for us.
The only reason is that Lordship.
Because of this case.
Pending, Lordship.
But here, my lord, it is subject to, so they know.
So Lordship may clarify it, Lordship, otherwise we have no problem. We have no problem, otherwise it is admitted fact that Lordship, he has deposited all the amount, Lordship, and government also sanction is there, Lordship.
What is the ground of challenge?
Challenge, Lordship, some complaint was filed by the petitioner, Lordship.
Who is the petitioner? What is the ground of challenge?
Challenge we have.
But this honorable court has not stated that, my lord.
Huh?
This honorable court has said subject to the outcome of the
repetition.
So that is why last time, my lord, the court asked that.
Okay, right in the main case. Where's the main case? This one, no? Okay, right. Right, huh? Heard Mr. G.N. Saiwala, learned senior counsel for the applicant slash respondent number 5. Also heard Mr. K. Gugoi, learned counsel for the excise department. No, Lord.
Deputy Commissioner.
Mr. R.R. Gugoi, learned standing counsel excise department. And Mr. K. Gugoi for
I am for response number 2 and 3.
2 and 3. Mr. G. Bhardwaj appears for the read petitioner. Let's come. Okay, you take this order dated 5/1/24, passed in the IA. Para 2, para 3. Okay. Okay, next para, you're right. Mr. K. Gogoi appearing for the Deputy Commissioner, Deputy Commissioner's office submit that the IMFL off license has not been issued to the applicant in view of the pendency of the present writ petition. On perusing the order
Letter 2922.
2922 passed by this court, comma, it is seen that
Last but one second.
it is seen that no, the court has observed as follows, invert commas, it is, comma, however, comma, made clear that issuance of license, comma, if any, comma, in favor of respondent number 5 shall be subject to the outcome of the writ petition, invert commas, please. The above observation made by this court in the order dated 2/9/22 shows that there is no impediment for the respondent authorities to issue the license, as the same in any event would be subject to the outcome of the writ petition. Then that's all. I won't say it. Consequently, in view of the above, this court is not inclined to pass any further. What? This court does not find any. In review of the rules says there about the IS stands closed.
Lost it. That will do.
Then in the main case,
Main case government has, I don't know when government has filed everything or not.
in the main case, have you filed affidavits? All of you.
Lordship, from a deputy commissioner's side, it was filed. My brother had to file.
You filed.
No file, waiting instruction.
Okay, right. The Mr. R. Gogoi appearing for the DC's office submits that affidavit has been filed. Full stop. Mr. R. Gogoi appearing for the excise department is granted
2 weeks.
2 weeks time to file affidavit in opposition. This is the matter after 2 weeks.
Okay.
Make your lordship. Lordship, your lordship, as per the order of the Lawajima court, your lordship, service is completed, your lordship.
Okay. So then we list it.
For admission hearing.
Okay, right. Mr.
I will say.
I Hussain appears for the petitioner while Mr. S. Datta appears for the PNRD department. Full stop. As per office note, service of notice is complete on the respondent number 7. Full stop. Are you filing any affidavit?
I've received some instruction, Lordship may grant 2 weeks time.
Mr. S. Datta submits that he has received instructions and will be filing affidavit within 2 weeks. This is the matter of 2 weeks.
My lord, as per office order, my lord, service report, your lordship kindly peruse the order dated 22/1/2023.
Yes.
Service report is awaited.
Service?
Report is awaited, my lord. Respondent number 5.
You see, respondent number 5 notice was issued only on 20 January.
Already appeared.
Oh, yeah, for respondent number 5. Okay, very good.
So we want 3 weeks time to.
Miss, your name?
K. Sharma.
Miss K. Sharma submits that she'll be appearing for the respondent number 5. And prays for 3 weeks time to file affidavit in opposition. Praise allowed.
I am appearing for respondent number 1 to.
Mr.
F. Kotobi.
S. Kotobi appears for respondents number 1 and 2.
1 and 4.
1 and 4. Are you filing any affidavit?
Going to file, will,
And he is also granted 3 weeks time to file affidavit in opposition.
there is an interim order, my lord, that's my.
Interim order to continue till the next.
Lordship, we have 45 lordship, petition in lordship. We have received instruction, all the license are cancelled, Lordship. They have come against the Lordship suspension order. It
Okay,
was cancelled. We have also given copy to them.
okay, right. So, cancel.
They have.
If it's cancelled, then what remains?
Yes, for.
Me heard, Mister?
APTO.
Huh?
APTO.
APT Hawk.
Matter may be pending, Lordship, in the meantime, Lordship will challenge this.
No, 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 no. Heard, Mister, what is the name? ABT Hawk appearing for?
Petitioners.
Acha, ABT appearing for the petitioner. Also heard Mr. K. Goyal and counsel for the same respondent.
That they have
Uh,
started.
the counsels for the party submit that the fair price shop license of the petitioner has been cancelled. Fair price shop of the petitioners
Petitioners.
have been cancelled. And in this regard, he has submitted letter dated 29/1/2024 issued by the District Commissioner Moregaon with annexures,
Including all the.
with various cancellation orders.
Lordship, Lordship.
The same is made a part of the record and marked as annexure X collectively. The writ petition is accordingly dismissed as infracted.
Lordship, Lordship.
Lordship, we need to obtain instruction. They have served our Lordship, whether petitioner got is not.
You go and challenge this in the division bench.
Oblige, your Lordship.
Your Lordship, in this case, I am appearing for actually
Item number?
Lordship,
Yes, you have not taken dusty service.
we have taken justice service, Lordship, but
Where is your affidavit of service?
Lordship, this copy of received, we have received it today only from the
Okay,
client.
then you find.
But Lordship, 2 and 3 is already completed. Service is completed.
And
As
I'm
per office.
appearing, and appearing for respondent number 4, your Lordship.
Oh, you pay for 2, 4. Okay, then it's okay.
I need 4 weeks time, your Lordship, to find my affidavit.
Okay, right. Miss
S. Sharma.
S. Sharma appearing for the
Respondent.
respondent number 4 is granted.
4
4 weeks time to file affidavit in opposition. In terms of the office order dated 6/2/24, service of notice is complete in respect of the respondents number 12. Mr. K. Goy appearing for, huh?
For one.
For 1. Are you filing any affidavit?
Lordship, here municipal board is the.
Okay. List the matter after 3 weeks, 4 weeks. Acha, in the meantime, the municipal board may also file their affidavit. 53. No one appears for the petitioner on call. What is this done
No
defaulter?
merit, my lord.
Huh?
No merit, my lord.
No one appears for the petitioner on call. But so husband if
Yes,
it's defaulter,
yes,
then
already admitted, my lord. So cause notice was given, my lord.
no one appears for the petitioner on call. Mr. S. Data appears for the PNRD. He submits that the writ petition has should be dismissed as it is without merit in view of the fact that the petitioner has admitted to her husband being a defaulter. However, however, in the interest of justice, list the matter on Friday or Monday. One chance will give them.
My lord. 58-51. All right.
What is this?
Malad, 3 last opportunities were granted to find their
Oh,
affidavit.
yes.
And on 5th of February, they were
Yes.
directed to find.
Mr.
an affidavit
Gogoi.
or like-
My lord, I have got 2 instructions, one from the government, one from the, my lord, executive engineer. My lord, one says, my lord, no comments everywhere. But other says, my lord, government says, my lord, there is some inquiry going on in similar type of cases. Just found that, my lord, some fraudulent withdrawal has been made, my lord, without doing, executing any work during that period in Dibrugarh. So I am, my lord, in between, my lord, I am hanging, my lord, 2 instructions. My lord. Chief engineer is yet to furnish an instruction. He, the authority will have to admit the, my lord, at the amount.
You have to, but you have got to make one affidavit.
Yes, that's why I am saying, my lord, I'm
Malad, they
holding
have
to-
admitted
on
it.
Monday, my
It's
lord, lordship
27.
may indicate, my lord, either affidavit or the respondent.
No time today. I've got to go to meeting now.
Friday next, because it's
No, no,
a
Monday,
second round of.
Okay,
it.
Friday. Monday also too heavy, I think.
Wednesday.
Wednesday is holiday.
Oh, Wednesday, Thursday.
My God, I don't know, this bench.
Coming
today, all
Friday,
everything
Next
is
Friday,
last-
my dear.
Coming Friday.
Next Friday. Okay, right, on the prayer of the parties. Now, due to paucity of time, this is the matter. On,
60.
Obliged.
Obliged.